snuck in too.
Which one?
This one is big kite.
Oh, yeah.
And then some of them are
They-
double.
They done, they done, they,
Should I just write that?
Sneaking into.
well, they tapped that in for me. Sorry. They knew what was going on.
Uh-huh.
See it.
Jeff, you do our invocation.
I will.
We're likely to set off a sort of competition with Europe and possibly other advanced.
Boy, they're gonna get small quick, huh?
Mhm.
Anybody gonna be a cat? ready to go? Testing. 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 Can everybody hear? Just read that. Yes.
Yes.
Thank you. Okay, folks, we are about at 6:33 p.m. We're officially going to call our meeting to order. Jeff, if you will do our invocation, sir.
Let's pray. Dear Heavenly Father, thank you for this day and thank you for the many blessings of life, Lord. We ask that you just be with us, not to make rash decisions, but what's best for the town of Woodfin and its future. Lord, we just ask that you watch over us and guide us and do things that honor you. In Jesus' name we pray. Amen.
Somebody like to make a motion that we approve our agenda, which had changed? Does everybody have a copy of our new agenda?
I'll move.
Okay, thank you. Second it?
Second.
Thank you. And the approval of our minutes from our previous meeting, somebody like to make a motion?
I move they be approved.
Second? Thank you. Okay, as part of our meeting, we usually have what's known as a public forum, which basically gets to deal with issues in Woodfin that are not on the evening's agenda. If there's anybody that has any issues that they would like to be heard about outside of the 3 or 4 issues that we have on our agenda for this evening, we open it up at that time. But to be honest, with as long as I think this hearing is going to last, I would probably dispose of that public forum at this time unless anybody has objections to it. Does there anybody want to be heard about items not on the agenda? Okay. Oh. So has that been addressed? The agenda is the only difference is that 291 Weaverville Road has been taken off the agenda? Okay, 291 Weaverville Road was taken off the agenda. Yeah, but the question was asked right after you posted it. I think you're good. Okay, I was saying, can you tell? I can't tell from here if anybody has a public forum. So if that's being the case, we will go ahead and close our public forum portion of it, and that brings us to new business. Mr. Saunders, if you'll bring us out, or Ms. Eisenhower, if you'll bring us out on our first issue or first agenda item.
Mr. Chairman,
Thank you, Mr. Sneed.
I apologize for having it at the moment, but on your agenda items, would it be prudent, and I don't know if you did this, but to move the first item A to last on the agenda?
We can do that.
But
Are we prepared to do that, Ms. Eisenhower?
it's just that we think, it appears that C and D will be relatively short and A is going to be fairly long. Don't want the people on the later ones waiting for a long hearing.
That's true, sir. That's true. We can get our business done and then develop, put all of our attention to item A.
And I think you needed a motion to amend the agenda to make item A the last item on the agenda.
Ms. Eisenhower, is that feasible? To move it around, make item, move the, okay. Somebody like to make a motion that we move agenda A to our last item and then continue? Okay.
I'll second.
Thank you. All in favor? Okay, it's, so we've amended our agenda. So item A will be our last item. So item B on our agenda would be the rezoning of Riverside Drive. Somebody to speak to that?
Originally, this request involved 4 properties. Since the advertisement of this request, 870 Riverside Drive has been asked to be removed from this rezoning. The properties that are listed are currently heavy industrial, but the uses that are on those parcels don't fit with that designation. So the town is recommending that those 3 parcels be rezoned from heavy industrial to community shopping. There are already three parcels in the area zoned community shopping, and that corridor just seems like a better fit for those properties.
Any of the property owners want to be heard on that? You state your name, your address.
Hello, this is David Todd with UNC Asheville. I'm here representing UNC Asheville. We own the property at 838 Riverside Drive. And I would just like to state for the record that we support this motion.
Thank you, sir. Anybody else to be heard? Any other property owners or anybody in the area have an opinion or discussion point?
I had a question. Do we know if there's a project slated for this site?
We do not.
Okay, thank you. I know they've been trying to sell it for a long time. I didn't know if it had been sold. Do you know if it's recently sold?
We do not.
Okay, thanks.
Anybody else to be heard on this issue? Anybody have any questions on the board? Anybody have any questions? We've actually modified this before. There are some other properties that we basically changed over to this designation. Heavy industry just doesn't seem viable anymore. Somebody like to make a motion that we approve this rezoning on Riverside Drive for these specific addresses? Somebody like to make a motion?
So moved.
I'll second.
I gotcha.
Jeff Angel, I approve the motion.
Ms. Lamb?
Barbara Lamb, I second the motion.
Do a vote by roll call, so Mr. Angel,
Yes.
Jay,
Yes.
Ken Razza, yes.
Barbara Lamb, yes.
Teresa Stoker, yes.
So that's 5 of us. Ms. Eisenhower? That's Mike Malling. He votes yes. Okay, that closes out item B on our agenda and brings us to item number C, a variance request for 30 View Street. Ms. Eisenhower and Mr. Saunders, if you'll.
All right, this is a variance that is requested for a 10-foot side yard setback reduction. The side yard setback is required to be 10-foot minimum according to the R7 zoning district. This is a very minor change to the setback. The house is already in place and the new homeowners would like to follow all the rules pertaining to Woodfin's Code of Ordinances. Process and timeline here, variance request sent to the Town of Woodfin Planning Department. Variance is accepted by the Town Planning Department. Meeting is scheduled for Planning and Zoning Board. Planning and Zoning Board hears request. If variance is approved, variance permit will be issued. Once permit's issued and the fee is paid, the variance will be granted. Staff's recommendation is to approve this variance request.
So, Mr. Saunders, is this variance, is it encroaching on another property?
No,
It is not.
it's on their property.
Okay. The first diagram I got, it looked like as if it was going to encroach on another property.
Yeah. That's an old view there.
Okay, okay. Yeah, that would have, it's hard to encroach on a neighbor's property. So,
I'm Brandon Hawkins, the owner of 30 View Street, asking for the variance.
are you a resident, Mr. Brandon? Are you a resident of? Wood-
I live in Weaverville, 209 Eller Cove Road.
Okay, but you are the property owner for
Yes,
30? Okay. And so the encroachment or the movement of another 10 feet, can you give us a reason for that?
yes, we're building multifamily there, so it's going to be a duplex, and according to the duplex, you have to have a 20-foot setback on each side, and we really have about 13 or 14 feet. And so that was the reason for the asking for a variance.
So if you don't, is there a monetary issue concerning the request for the variance? Is it going to cost you more if you don't get the variance, or?
No, we own both pieces of property, left and right of the variance. So it doesn't, it's just trying to use the space to the maximum, basically, the width.
Yeah.
Our lots are 66 feet wide approximately.
Okay.
We actually got a variance request last year for the duplex that's currently being built.
Okay. Does anybody have any questions? Okay, so would somebody like to make a motion to accept the variance of 10 more feet on this property line?
I move we accept the variance.
Okay,
Teresa Stoker.
somebody second it?
Jake Grimmett, second.
Okay. All in favor, roll call, Mr. Angel?
Yes. Jake Grimmett, yes.
Ken Razza, yes.
Lamb, yes.
Teresa Stoker, yes.
So the presentation of the zoning map, Ms. Eisenhower, is that just something you want to go over, or it's been updated and you can tell us?
So you have a version of this map in your packet, the last page, blown up version of the map. We do not currently have an official zoning map, so with the help of Land of Sky Regional Council, we have created a new map that will be our official map, and so I wanted you guys to look over it and give me feedback that you might have. We'll be taking this map to the Board of Commissioners at their next meeting for approval. So I just wanted to present it to you and get feedback from you guys.
Okay, thank you. Did this address like the last meeting we had when the folks had addresses that were listed on the GIS as either not being a Woodfin resident or having an
This
address?
map is simply identifying the zoning designation for each
Gotcha.
parcel, but we are in the process of working with Buncombe County on incorporating this data into their GIS system so that it is available for public consumption.
Okay,
We haven't quite gotten there yet, but we are working on it.
okay, because there were some folks that were confused as to whether or not they had a standing right to discuss issues when notifications went out
Right.
on property borders and whether or not they could be heard on those issues. So, well, thank you. Does anybody have any questions about the map? We can go by it as best we can right now. It's not 100%
If you see anything
correct.
that sticks out, let me know and we can get
Right.
it changed.
Yeah, but you don't believe it's 100% correct?
I think it's 99.9% correct, but I could be wrong. So
Okay,
let me
okay,
know.
that's just that was my question. How much credibility can we give to it? If you assure 99, that's great. Do we have to make a motion that we accept the map, or?
No.
Thank you.
Just if we have to tell him that his variance is okay.
Your variance has been approved, sir.
Thank you.
Okay. All righty, so then we go back to our conditional use permit item. So somebody want to speak to that issue? Ms. Eisenhower, Mr. Saunders? Or Mr. Sneed, there you go. Not used to having you with us, Mr. Sneed, so you'll have to bear with us.
Talk to the microphone. Suggestion, we know at least at this point, there's 2 lawyers involved. You might want to find out if they're online and ready to proceed. You got both of them? Okay,
But we'll get Mr. Nord vocally saying that he could hear and that he's on board. Mr. Nord,
Good evening. I can hear the board. Thank you.
okay. And the other attorney is? Mr.
Derek Allen, I'm here. I can hear you.
okay. Couple of suggestions is obviously getting an introductory statement from your planning director, just not a pro or con, but basically a statement of what's coming before you tonight. Understand that there are applications for witness or people to be found to have standing. My suggestion is open the public hearing so that everything's going on the record, that probably Adrian should give her statement, her staff report, just so you've got a grasp of what's going on, so you know what you're talking about. And then let each of the attorneys, of course, Mr. Allen represents the developer. He automatically has standing. That's not an issue. Mr. Noor, I understand, may represent property owners nearby or associations. Probably after the opening statement by Adrian, then let Mr. Noor call up his witnesses that he hopes to show have standing and put on that evidence for this board to determine if they have standing or not. As we discussed earlier, if they don't have standing, they don't get to cross-examine, they don't get to offer other witnesses. If they do have standing, then they, through their counsel, they can put on other witnesses and cross-examine the applicant's witnesses. That's my recommendation for procedure. Open your public hearing, statement of what the case is about, Adrian, then the quiz to go through the process of seeing if there's people out there who have standing.
Thank you, Mr. C. Ms. Eisenhower, if you'll make a motion to open the public hearing. Somebody make a motion.
I make a motion that we open the public hearing. Teresa Stoker.
Somebody second that.
I, Jeff Angel, second that.
Approval, Mr. Angel?
Yes.
Jay Grimmett, yes.
Ken Razzie, yes.
Lamb, yes.
Teresa Stoker, yes.
Okay, so this is a request for a conditional use permit for exceeding the maximum building height of 35 feet At this time, there are no additional approvals requested for the project. The ordinance contains two separate provisions regarding height limitations, and they are as follows. Section 54-241 states, heights of buildings shall not exceed 35 feet unless written permission is first secured from the appropriate district or town fire chief in order to determine, one, if the height of the structure exceeds the firefighting capability of the fire department, and two, to determine if the structure meets fire safety standards. The second provision is section 54-316 that allows for the conditional use permit hearing for buildings to exceed 35 feet in height. Based on what we know at this point, staff recommends approval of the conditional use permit if the ordinance standards provided for, conditional use standards provided for in the ordinance are met, and they are as follows. One, the establishment, maintenance, or operation of the conditional use will or will not be detrimental to or endanger the public health, safety, morals, comfort, or general welfare. Two, the conditional use will or will not be injurious to the use and enjoyment of other property in the immediate vicinity for the purposes already permitted and or substantially diminish and repair property values within the neighborhood. Three, the conditional use will or will not impede the normal and orderly development and improvement of the surrounding property for uses permitted in the district. Four, the exterior architectural appeal and functional plan of the proposed structure will or will not be so at variance with the exterior architectural appeal and functional plan of the structures already constructed or with the character of the applicable district as to cause a substantial depreciation in the property values within the neighborhoods. Five, adequate utilities, access roads, drainage, and or other necessary facilities have not been or are being provided. And six, adequate measures have or have not been taken to provide ingress and egress so designed as to minimize traffic congestion on the public streets. Again, those are the standards that are provided for in our zoning ordinance. And then secondly, staff recommends approval contingent upon approval from the appropriate fire district or chief. And with that, I'll take any questions.
Anybody have any questions, Ms. Eisenhower? Thank you, Ms. Eisenhower. Mr. Noor, can we hear from you concerning folks that have a right?
Absolutely, Mr. Chairman. Good evening, members of the board. My name is John Norm with the Robertson Stevens Law Firm here in Asheville. I represent three different parties that are seeking standing this evening. The first is Galen Wilcox. I think Mr. Wilcox is on this evening, so I'd ask him to turn on his camera. And I guess I would ask the board members, do you have the affidavit that was provided along with Mr. Wilcox's application, just for your reference?
Yes, sir.
Okay. Mr. Wilcox, I'm going to ask you a couple of questions about where you live and your relationship to the development in order to provide testimony to the board related to the special damages you would sustain as a result of the proposed project. Can you tell the board where you live, the property that you own?
Yes, I live at 63 Hornot Circle in Asheville.
And where is that? Actually, I'm going to throw up on the screen here. Mr. Hardy, if you could let me screen share, please. Okay. Mr. Wilcox, can you see the document that I put up on the screen here?
Yes, it's my affidavit.
That's your affidavit. And at the last page here, are these your signatures?
Yes.
Okay. And on the first page, we're looking at in paragraph 4 here, a map of some sort. Can you tell me what the blue outlined property is on that map?
That's 63 Hornot Circle, my house.
And that's your house in the outlined blue, correct?
Yes,
Okay, and what does the green star represent on that map?
that is the property to be developed.
Okay, so you're a budding landowner to the proposed development, is that correct?
Yes.
Okay. And what documents have you reviewed in order to prepare your testimony today?
Well, I reviewed the original proposal made in December, which I received on December 21st. I reviewed a letter from Allen, Stahl, and Kilborn from Mr. Allen to Ms. Eisenhower of the Woodfin Town Board, dated January 22nd, 2001. And then also, of course, the notice of public hearing on a conditional use for heights to exceed 35 feet, the one we're discussing now.
Did you review the revised site plans that are dated January 26th of this year?
Yes.
Okay. And again, I'm going to throw up on the screen here your affidavit again. Can you tell us what we're seeing here in this? What are the green stars represent in this schematic?
The green stars are the two entrance points to the development.
Is the one on the bottom right-hand corner the one on Richmond Hill Drive?
Yes, that is Richmond Hill Drive. Yes.
And what does the blue dot that's on this indicate?
That looks like my house.
Okay. When you reviewed these plans, what concerns did you have about the impact this development might have on your property?
Well, first of all, was traffic.
And is that related to the entrance on Richmond Hill Drive, your concern out of traffic?
Well, yes, although of course it's related to the proposed entrance on across the river, across the bridge. If the bridge never gets permitted, which it's not even applied for, then all the traffic has to come up Richmond Hill Drive.
So your concern is related to the volume of traffic that would come down Richmond Hill Drive with the proposed development in the event that the bridge is not approved. Is that correct?
Yes.
Okay. And are these just your concerns, or did you engage any experts to evaluate those concerns?
Well, I did, through you, retain a traffic engineer, Daniel Finley, who did a traffic study that determined that in his professional opinion, the applicant has developed acceptable mitigation with the bridge. And without the bridge, his analysis is that the volume to capacity ratio will be significantly exceeded if the traffic has to use Richmond Hill Drive. And
if I say that back to kind of summarize, after retaining the services of the traffic engineer, Mr. Finley, his analysis showed that if the bridge is completed, is not completed, that will result in excessive traffic and congestion on Richmond Hill Road. Is that your understanding?
Yes.
Okay. And how often do you use Richmond Hill Drive and Pearson Bridge Road towards the intersection of Riverside Drive?
Well, I mean, before COVID, many times a day, normally. After COVID, of course, it's cut way down. Although, ironically, the total traffic coming up has actually increased as more Asheville citizens are looking for ways to recreate outdoors. Richmond Hill.
Would you say you use that thoroughfare? What percentage of the time are you using those roads to access the services in Asheville that you're using, or going to the doctor or grocery store or something like that?
Well, I would say at least 90% of the time. The only other way down is down Louisiana Avenue.
Okay. Would that be out of the way to the services that you typically use, or a longer route?
Yes, it's a longer route and out of the way for my normal services. Plus, the traffic on Louisiana is already pretty sticky, and they have two developments going in there now.
And so, so after you had that review done, were your fears confirmed about the volume of traffic potentially, or were they kind of set aside?
Well, they were definitely confirmed. The engineer approximated 10,000 trips a day going in and out of that proposed development. That's way too much for Richmond Hill Drive to even imagine.
Okay. Did you have any other concerns about the proposed development?
Yes, I did. I went to the North Carolina Steep Slope Calculator, which allows you to basically calculate the average slope of any parcel, at least in this part of North Carolina, and found that the slope of this development is just over 28%. Since the developers from Florida and didn't have a lot of experience with this kind of land or this kind of slope or this kind of anything. Of course, that's a major concern.
When you say a major concern, is it because of the slope of the hillside and the development that would be on it?
Well, it's really because the way this property is situated, there's really only two places for stormwater to go. Down into the French Broad River, which is, kind of an important part of my life now, and into Richmond Hill Park, which is another kind of important part of my life.
Well, let's talk about that. So stormwater is the concern that you have there, and that concern is kind of exacerbated by the slope or the steep slope of the property that's being proposed for development. Is that a fair summary?
Yes.
Okay. So, so you mentioned that the French Broad plays an important role. How often are you interacting with the French Broad or recreating on the French Broad or observing?
I still walk through the park down at least overlooking the French Broad, and sometimes walk down all the way to the French Broad and walk along the tracks and walk back up Richmond Hill Drive, all the way back up into my Pearson Bridge Road and Richmond Hill Drive all the way back home.
And how frequently do you do that?
Well, every day. I get out there every day in the park.
And how would your ability to recreate with the river and observe it be impacted by the stormwater that you're concerned about?
Well, I mean, obviously, we're talking about major sedimentation washing into the river. So it would raise the river level and make it uglier.
And you're referring to the sedimentation there, meaning runoff from the development ending up in the river, making it less attractive for you to use?
Yes, yes.
Okay. And I think I'd asked you how frequently you're recreating. Is that daily, weekly? How often are you getting down there?
Daily. Okay.
And did you talk with anyone about your concerns about stormwater and sedimentation based on your review of the project? Any experts, I should say, any experts specifically? You may have talked with a lot of folks, but just experts.
No.
Well, did you talk with Hartwell Carson, who's the French Broad River keeper?
If he's that kind of expert, then yes, I've talked to Hartwell Carson about this.
And did he talk with you about his impressions about the impacts of sedimentation and stormwater?
Yes, he's very concerned as well. It's pretty obvious looking at the property that will happen.
Okay. And how, one of the things with standing that we'll talk about is how are your damages distinct from a community as a whole? And so I want to talk a little bit with you about that. You'd mentioned that you use Richmond Hill Drive, Pearson Bridge Road, and the intersection at Riverside Drive pretty much 90% or more of the time. Is that right? Is that accurate?
Yes.
Okay. Does everyone, if you were to draw, let's say a mile radius around that, to your knowledge, are you one of the few people that are using that route to access your services?
Yes.
And how would you be impacted being, right outside of one of the entrances of this development if the bridge was not constructed?
Well, I mean, obviously the traffic noise, the dirt, the lights coming through the window, the backing up, beep, 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 the noise of high impact, high density human living.
And that would be different than someone who might even live a few streets down, correct?
Yes, absolutely. Being an abutting landowner.
Is that route, to your knowledge, the exclusive way for emergency vehicles and other medical vehicles to access your home?
Yes, it is. And being a 70-year-old man, I'm also concerned about that. The intersection of Pearson Bridge Road and Richmond Hill Drive is a blind 170-degree turn up a steep hill. It's very dangerous. The developer, in an unguarded moment, speaking to me, even described it as a death curve and stated, "I know it's not safe, and yet that's the way all the traffic is going to have to come up here."
If the bridge was not constructed, let's be.
It's not constructed.
Okay. And you using Richmond Hill Drive in that way is different than even members of the town of Woodfin or residents of the town of Woodfin that live across the river, correct?
Right. I mean, when I walk up, when I go down the tracks and walk up, I walk all the way up through that intersection, and it's a little bit scary sometimes.
And that's distinct to you and those that rely on that interchange, that intersection at Pearson Bridge and Richmond Hill Drive, correct?
Right.
Okay. Would that be, give me just a second, Mr. Chairman. I just want to look back over my notes for a second. Oh, Mr. Gala, or excuse me, Mr. Wilcox, have you made contributions or otherwise support organizations that protect or are related to water quality in the French Broad River Basin?
Yes, I have contributed to Mountain True and will continue to.
Okay. Those are my questions for Mr. Wilcox, and I'll say to the board, there was a summary in his affidavit of the sort of the analysis that has been done by our traffic engineer. I'm happy to put that testimony on at this point, but I worry that would get us down a road that's much more into the substance of it than a standing question. But I'm happy to do that if there's any questions about both the evidence that we have related to the traffic impact, not only in addition to the allegations that are included in this affidavit.
You'll have access to that information from Mr. Finley?
Mr. Finley is he's on the call, and we have that report and we're ready to go. But I don't want to kind of get into the substance of that inappropriately before the board's ready. I think he just turned his camera on. We can do that now if the board has any questions to kind of substantiate those concerns Mr. Wilcox has expressed, or we can wait until later in the hearing for that.
We could probably, I just wanted to know if he was accessible as in addition to the stormwater drainage issue, the witness that he spoke of.
Yep, Mr. Carson is available as well and is on the line. I'm happy to, I'd like to just address a little bit of case law before, maybe the board should ask some questions, but then I have a little bit of argument that I'd like to make just in support of Mr. Wilcox's meeting the standards for standing.
Sure, but as long as we're just talking about Mr. Wilcox standing right, I don't believe we need to get into the specifics of Mr. Finley or of the stormwater guy at this time. We're just reviewing his right. Is there anything else to add, Mr. Noor, concerning?
Just, I will share my screen one more time. I wanted to provide the forgive me. Can you see what is titled Mangum versus Raleigh Board of Adjustment at the top of my screen there, board members?
Yes, sir.
Okay. This is a case that talks about special damages. This is a North Carolina Supreme Court case. And I think Mr. Sneed referenced this earlier during your training in talking about what is necessary in order to show special damages. And what we've done here is and I've highlighted that text. It says petitioners may have made sufficient allegations to establish special damages for the purposes of standing through their testimony regarding increased traffic, increased water runoff, parking, and safety concerns. Then later on, it says, as well as secondary adverse effects on petitioner's business. I don't want to revisit this every time we have, I've got two more clients that will be applying for standing, but I wanted to note that impacts on business under the Mangum case have been identified as sufficient for both for alleging standing. And so at this point, you heard from Mr. Wilcox. He's provided a sworn statement, also testified about the concerns he has regarding traffic. He's retained a traffic engineer that will provide an expert opinion to the board on that issue that confirms his concerns if the bridge were not to be built. Additionally, he's expressed and alleged special damages related to increased water runoff, and we have an expert in that area as well. And so I think for Mr. Wilcox, we have alleged and are prepared to prove during the hearing that special damages would be suffered by his particular property that are distinct from the community at large. And as Mr. Wilcox testified, that distinction relates to his pretty much exclusive ability to use Richmond Hill Drive to access Pearson Bridge Road and then get to his services and appointments in the Asheville community. And that being different from a broader community of folks who can have access to other routes to get to those locations. And even those within the town of Woodfin who might be across the street. And so we believe that we've met the standard for standing, would ask the board to approve Mr. Wilcox as having standing in this case.
Mr. Allen, do you want to be heard on that issue?
I've read and reviewed the affidavits that have been submitted, and what I would suggest, if the board pleases, because they can go into just a couple of different categories of alleged damages, and I'd rather address them all at the same time instead of doing them each as their own. I would note for the record objections to, and Mr. Knorr forecasted this, objections to items of testimony that are outside of the witness's expertise. I understand that's supposed to come later. I'll also object to any hearsay testimony and any leading questions. But I would also suggest to this board that we wait and do the standing determinations at the end. And I think they all go into a couple of different categories.
We would, Mr. Chairman, we'd ask that each of these individuals own separate piece of property that are distinctly located in different purposes for engaging in standing. So we would ask that an individual vote be taken on each of those parties on their standing one at a time, so that it's clear from the record which factors were considered related to each of those parties. Even though sometimes they may overlap, Mr. Wilcox is not tied to any of the other parties that have applied for standing, and we'd request that his application be treated separately.
I agree. So we'll take a roll call vote on whether we would accept Mr. Wilcox as standing right to object.
Mr. Hardy, if we're going to do these one at a time, then I would like to go ahead and cross-examine Mr. Wilcox then.
Did you just want to wait until after we do all three at the same time, sir?
I was going to wait and do that at the end, but if we're going to make the vote on his standing, then I don't have any choice but to go ahead and cross-examine Mr. Wilcox now.
Okay. That's why I asked if you want to do it on Mr. Wilcox and individually as we hear each of their testimony.
That'd be fine. Mr. Wilcox, do you understand from your traffic engineer that additional height above 35 feet will not add units to the proposed development?
Well, I understand that from the traffic engineer.
Or do you understand that the density has nothing to do with the height of the building?
Well, obviously, it seems like the more you build it higher, the more density you can get in there. I guess I don't understand the question.
Okay, well, the density for this proposed project is 17 units an acre.
Yes,
And we have proposed that we be allowed to exceed 35 feet, which would allow us to put that density in 7 buildings.
well, okay, even if, so even there, if you're gonna put that many, if you're gonna stack that many stories high, that means you're gonna have to dig down deeper to get it into, to get it down. Are they gonna have to blast when they're digging, if they have to go that deep to get the height where they want it? I mean, that would obviously impact my house greatly.
Okay, well, I'm asking about the traffic, and the traffic is related to the number of cars. And the number of cars ostensibly would be related to the number of units, correct?
True. Yes, that's true.
Okay. And if you have larger footprint buildings that are lower in height, you're going to have more impermeable surface. Does that make sense to you?
Yes, in general.
Okay.
I mean, if you have, so if the wind isn't coming in, if it's raining and there's no wind, I guess I can see how a taller building with a smaller impact would have less groundwater. But if there's wind blowing, it's just going to sheet right down the side of the building, then across the impermeable surfaces and run down the hill.
Okay, let me share my screen here. Mr. Wilcox, can you see this screen I have here?
Yes.
Okay. This I will represent to you is a plan that shows 3-story apartment buildings.
I thought it was 5-story apartment buildings. I'm sorry.
Okay. Well, the 3-story apartment buildings are what the developer can do as of right now, meaning that he doesn't have to ask permission from this Planning and Zoning Board of Adjustment to do this development right now.
Characterization for the record, and I think the document that's shown on the screen indicates 5 stories at the bottom right-hand corner.
Okay. Yeah, that's the 5-story one.
Is there a reason that chat has been disabled at the moment?
This is Ron Sneed. I have asked that the chat feature be removed because you're getting a lot of people not under oath to be putting testimony into this hearing. So I've asked the chat be disabled.
Ron, we would just like for the record, because the chat was enabled, we would hope that that's being preserved for the purposes of Open Meetings Act.
Okay. Mr. Wilcox, I now have the 3-story building up, and I'll show you the 3-story building, which is what the developer can do as of right now. And I'll show you the second one, which is the 5-story building. in the 5-story building, does it make sense to you that the 5-story buildings are going to have a smaller footprint from a top down?
You know, I'm really trying to understand what you're saying. So this is the 5-story. So what's the difference between that one and the one in front of it?
Okay, well, they both have the same number of units. And if you have the same number of units and the same number of buildings, the shorter building is going to have to be more spread out. Does that make sense to you?
You know, I guess it makes sense to me, but I don't know how I mean, the original was 7 5-story buildings. So where does it, and now we're talking about 7 5-story buildings, aren't we? Isn't this?
Well, I apologize because of the way this hearing has been set up. We've not gotten a chance to introduce the project. And so maybe I should back up a second. This project concerns the ability to put a number of units in apartment buildings on this property. This property is zoned Mountain Village and has been zoned Mountain Village for years. Mountain Village, under the version that we have applied under, which was in effect in December of 2020, allows 17 units per acre. The 17 units per acre times the acreage gives us the number of units. That number of units doesn't change based on how many buildings we have. However, we have asked to exceed 35 feet so that we can put that same number of buildings into taller buildings that take up less footprint. The less footprint that it takes up, the less stormwater that's generated. The less footprint that it takes up, the more green space that can be preserved. The less footprint that it takes up, the further the buildings can be placed from the river, from the boundaries, from one another. It just allows more room. If
For the record, we'd like to object for, I mean, this isn't
Let me
a
finish,
question
John.
as much as
John,
a
John,
presentation.
I gave you plenty of space to talk. And I'm making sure he understands the question because we haven't had any introduction of the actual project. And so
I understand. I'm just noting it for the record, Derek, and so that that's preserved in the recording.
That's fine, John. I gave you plenty of room to get what you wanted to get in. And I'm just asking if he understands that's the same number of units, whether it's in 3-story buildings or 5-story buildings. You understand that, Mr. Wilcox?
Yeah, I understand that, but I don't understand why we're talking about 3-story buildings because I never saw a proposal with 3-story buildings. I don't think the original proposal was for 7 5-story buildings, wasn't it?
3-story buildings is what the developer can do as of right now, because they're shorter than 35 feet. What we're asking to do is exceed 35 feet. So instead of 3-story buildings, we would have 5-story buildings.
Well, I mean, I guess as far as that impact, obviously, as far as the visual impact, we'll be looking up at people's apartments if they're building up that high. So, you know, okay. So what's the question?
My question is, if you have the same number of units, are you going to have the same number of cars, whether they're 3-story buildings or 5-story buildings, if it's the same number of units? And I was just making sure you understood that math. But if that question's not clear, then I'll just move on.
Okay, well, okay. Okay, let's move on.
I have no further questions. I would make an argument that none of these issues are related to the one thing that is being asked for here. The only thing in consideration here is not the underlying project, but can this developer exceed 35 feet? That is the only thing that's being asked for. And unless these alleged damages relate to that, then there is no standing. It cannot be any standing. If you look at where the standing rule comes from, the standing rule comes from General Statute 160D-1402. And 160D-1402 C2 has 2 different parts to damages to allow for standing. And Mr. Norris concentrated here on special damage and is trying to show that Mr. Wilcox is somehow unique in his damage. I'll get to that in a second. But the bigger part of this is that the damages have to be the result of this decision. And the point I was trying to make with Mr. Wilcox with these questions is traffic is not going to change because of the height of the building. It's going to be the same amount of traffic no matter what. The slope that's out there and building on top of that slope is not going to change if it's a 3-story building or a 5-story building. It's going to be the same issue with the slope. Stormwater, if anything, is going to be less because you're going to have less impermeable area spread out over taller buildings with smaller footprints. And so they don't even pass the first part of this, which is they would be damaged as a result of the decision. Even if there is some kind of argument that says that the result of the decision is what causes the damages, all of these damages, traffic, slope, stormwater, all of those are damages that are suffered by anyone. If they're suffered by anyone, they're suffered by everyone. Everyone wants to go to the park. Everyone is concerned about French Broad River. Everyone who lives out there is going to have a traffic concern. So none of those damages are going to be unique. But at this point, I would circle us back to the whole reason we're here. All those things I just mentioned, traffic, stormwater, slope, they're the same whether we exceed 35 feet or not. And so if they're the same whether this gets approved or not, then they can't be damages as a result of the decision.
I may be heard just briefly, Mr. Chairman, in response.
Yeah, we're about it.
I'm just going to share my screen here. This was the worksheet, that Ms. Eisenhower provided to the board and discussed at the beginning of the hearing. And so what Mr. Allen has said is because the maximum height is 35 feet and we want to exceed that, you all can't find damages unless it's related to height. But what I'd like to show the board is again, the language of the actual statute here. You just give me a second. Yeah. So you'll see here, it says a conditional use permit must be acquired for buildings to exceed 35 feet in height in addition to the restrictions of this article, So you have to go through the conditional use permit process. As Ms. Eisenhower pointed out to the board earlier this evening, the following conditions apply. And that's conditions 1, 2, 3, 4, 5, and 6, okay? The workspace that you all, or the worksheet that you all were provided, also talks about those. And so these are the same things that Ms. Eisenhower has pointed out to the board. You all have to receive evidence on to determine whether you can approve this project, evidence on these 6 different factors. And that's again here. Will not be related or endangered to public health, safety, morals, comfort. And again, in parentheses here, specific evidence regarding height, bulk, scale, and appearance. Number 2, will or will not be injurious, specific evidence regarding noise, traffic, environmental, and other concerns. Number 3, will or will not impede the normal orderly development or improvement of surrounding properties. Again, specific evidence regarding noise, traffic, environmental, and other concerns. Number 4, and I'll just skip down to 5 and 6 because I think those are the most applicable here. Adequate utilities, access roads, drainage, and other necessary facilities have or have not been or are being provided. Again, expert testimony regarding traffic, specific evidence concerning stormwater. And then the next one, ingress and egress. This is all related to traffic. So the ordinance itself says you have to get a conditional use permit, and the conditional use permit standards say you have to present evidence that suggests that you have met each of these, produce evidence that suggests you've met each of these standards. Mr. Wilcox's affidavit and testimony alleges damage on 2 of those related to stormwater and traffic. And so we think that's specifically related to the standard the board has to evaluate. And then as to his property versus the rest of the community, he specifically talked about his proximity to the development, being an abutting landowner. His reliance on that road is his exclusive means in order to access the services. And that's different from people who don't live on Richmond Hill Drive. And that's a relatively small group of people compared to a broader community, even if you were to draw a 1 mile radius around the project. That's how those are distinct from the rest of the community. As for the stormwater, that's someone who lives in Asheville doesn't necessarily have the same interest in water quality in the French Broad as someone who recreates on it like Mr. Wilcox does, or someone, as we'll hear with other folks who work in that space on a daily basis to protect water quality. And so again, those damages are distinct to him as opposed to others, and we'd ask that he be approved for standing. happy to answer any questions the board might have.
No, thank you, sir. I think we're ready to rule on Mr. Wilcox.
I'd like to point that out since Mr. Noor was kind enough to share with us these standards on 54-255 conditional use requirements. I want to go back up to the very beginning of that. So if you look at the very first sentence of that, it says, and this is the important part, the following conditions will apply to all uses listed as conditional in the permitted use table. In the permitted use table, and I will represent to you, and we can take as long as we need, that height exceeding 35 feet is nowhere in the permitted use table. And you'll see if we have to try to apply those 7 standards to 35 feet and whether that matters or not, you'll see how silly that is. The only standard that applies in this entire thing is related to fire safety, and that's in a different section of the ordinance. But if you look at this right here, the following conditions will apply to all uses listed as conditional in the permitted use table. You have to conclude that 35 feet being exceeded is not in the permitted use table. Therefore, these 7 conditions absolutely do not apply to the consideration of whether or not you can exceed 35 feet.
I just briefly note, as Mr. Sneed mentioned earlier this evening, I mean, the language says that it requires a conditional use permit, and these are the standards that are listed under that ordinance. I think that's the clearest interpretation of what's required in order to achieve that conditional use permit. Would ask the board to consider it.
If the ordinance was otherwise silent as to what was required, then maybe that's the case, but the ordinance is not silent. The ordinance provides its own special determination of what needs to be considered, and that's in section 54-316. And then let's see, for the appraiser, it ends up being conditional use, yeah. What's the section on? In 54-241, that is what tells us how to consider and what standard to apply for height being exceeded by 35 feet. It's very specific. And in that, it says that the height of the building shall not exceed 35 feet unless written permission is first secured from the appropriate district or town fire chief in order to determine if the height of the structure exceeds the firefighting capability of the fire department and to determine if the structure meets fire safety standards. Those are the standards that apply to consideration of 35 feet, not these 7 standards that would be very cumbersome to try to apply to 35 feet and which are expressly accepted out by the very first sentence of 54-255. That's all a long way of saying, unless Mr. Wilcox has something related to the fact that he's going to be damaged as a result of a higher building being approved, then he has no damages that he can even allege. If he has no damage, then he has no stand.
The board chair indicated you're ready to vote on this. We obviously disagree on this point, but I'm happy to answer any questions the board members might have or allow you all to proceed with voting.
Anybody on the board have any questions, Mr. Noor or Mr. Allen? Okay, the board take a vote on accepting Mr. Wilcox right. We'll do it by order.
You like to prep, somebody want to preface that with a motion to accept?
Yeah, we'll make a motion that we go ahead and accept Mr. Wilcox as for his right to be heard. Somebody make a motion.
I mean, that he has the right to be heard. Teresa Stoker.
Seconded.
Jake Remitt, second.
Before you vote, probably need some clarification to get the magic words in. Is that a motion to find that Mr. Wilcox has standing to proceed as a party in this action?
That's what I was meaning. Is that suitable?
Yeah, I just want to make sure it sounded like you were just accepting as a witness.
No,
not finding you as
no,
having standing.
for his right to be heard and to be a witness
And have a stand.
and have. a
And Mr. Sneed, I think that's a good point. I was getting ready to pipe in. We in no way have a problem with Mr. Wilcox testifying as a witness, but there is, we have laws, and a party with standing carries with it some carries with it legal rights. And we have to look at these things and apply the laws, and that's what we're asking to do. We have no objection to Mr. Wilcox continuing and offering up testimony as though he had standing. We just disagree that he has standing. We do not think the law supports that he has standing, but we have no problem with him testifying.
And again, we would offer him up for standing purposes.
So we've already had the motion on standing, on the standing, so we will take a vote at this time. Mr. Angel.
Yes.
Jake Grimmett, yes.
Ken Raza, yes.
Lamb, yes.
Teresa Stoker, yes.
Guy back there.
Yeah, it's Mike. Yeah. So did you record Mike saying yes? Okay. Mr. Noor, you have your next folks.
Yes, Mr. Chair, at this time, we would submit, and this is the application for Own Sanctuary, supported by the affidavit of Shelley Stanback. Ms. Stanback, are you on the call? I think I saw you earlier. And you're still muted, Shelley.
Thank you.
Okay. I will, for the board's convenience, I'll try not to be duplicative of this, but I think there are some different things that need to be covered with this application versus Mr. Wilcox's. Ms. Stanback, can you tell the board, give the board your full name?
Shelley Stanback,
Okay. And Ms. Stanback, what is your current position?
CEO,
Of what institution?
Oshun Mountain Sanctuary, and we do business as Om Sanctuary.
Okay, and I'm going to throw up here on the screen this affidavit. Is this your affidavit, Ms. Stanback?
Yes, it is.
Are these your signatures on the last page there?
Yes, it is.
Okay. And as the CEO, have you been authorized of Om Sanctuary? Were you authorized to submit this affidavit on behalf of Om Sanctuary?
Yes, I have.
Okay. And what properties does Om Sanctuary own in relationship to the proposed development? I'm going to scroll down here maybe to assist. But can you tell us what we're seeing here on page 1 of your affidavit with the blue lines here that are indicated?
Yes. We have eight properties that make up our whole piece of property.
Okay.
So there's
And,
eight different PIN numbers.
and is this one of those properties, Ms. Stanback?
Yes, it is.
Okay. And the green star, that indicates the development?
Yes, it does.
Okay. And this particular piece of property is larger than just what's depicted here on the screen, correct?
Yes, it is.
What is that property as a whole? What role does that serve for the sanctuary?
That property is 42 acres that we had put into a conservation easement so we could run programs that are connected to sustainability, and then also more meditative programs such as forest meditation. It's set up to be an educational aspect of what we do there.
And does that extend all the way down to the French Broad past the railroad tracks, that property there?
Yes, it does.
Okay. And as I'm scrolling down on page 2 here, again, the upper left-hand corner, the green star represents the development, correct access point?
Yes.
And at the bottom here, and what are these blue dots?
I can't see those blue dots. Those blue dots represent Om Sanctuary property.
Those are properties that are within Om Sanctuary, correct? I had a hard time hearing you there.
Yes.
Okay. And what are these two, the two dots at the very most southern end of this depiction here? What are those properties? What are on those properties?
That is 86, and this represents some of our dorm housing, and also one of them is our caretaker and safety and maintenance person.
And do they have to cross Richmond Hill Road in order to access the rest of the facilities and services with Om Sanctuary?
Yes, they do. When it's not COVID times, the dorm lodging can hold up to 6 different participants, and they may cross the road up to 3, 4, 5 times to get to the main campus. And our caretaker, there's something happening there, I'm not sure, but it's, and then our caretaker, he crosses at least 4 times, 5 times in a day.
Okay. And I'm gonna just stop sharing for a second there. What have you reviewed the application and the site plan that were submitted in support of the development, Ms. Stanback? I'm sorry, I couldn't hear that. I want to make sure the board got that too.
Yes, I have.
What concerns did you have after reviewing that application and the revised site plan?
Well, traffic was number one. The original site plan said, their engineer said 3,000 plus. And I remember asking the question, 3,000 plus could go up to what? Up to what? And so when we saw the second one, that it was still, the 1,545 units, traffic was still very, very top on our list there. And of course, that's when we, asked to have a traffic study done.
Did you have the same engineer that Mr. Wilcox engaged do an analysis for your purposes at Om Sanctuary?
We did. We did. And
without knowing, I guess I'd ask the board to, were your concerns about traffic addressed, or were you still concerned after receiving that analysis, Ms. Stanback?
Well, after the analysis, I mean, it was so much higher than the image of 3,000 plus. This one went up 10,000, which just floored me when I saw it. And this is what, Daniel Finley had brought us. He said, and it was due to substantial traffic volumes would because of the intensity of the proposed land use.
Well, without going too far into the content, because I think the board wants to keep that separate from the concerns you had and that you retained an expert. But I'll kind of ask a different question. Your clientele and staff that come to Om on a daily basis, do they use the Pearson Bridge Road and Richmond Hill Drive access point?
Yes, those are the primary access point, and Richmond Hill is the access point. Even if you came from a different direction, you had to go through Richmond Hill Drive.
Okay. So you'd say, how much of the traffic to Om Sanctuary relies on that intersection, do you believe, if you think you can put a number on it? Would we be talking in excess of 90%, less than that? What?
Well, Richmond Hill Drive is 100% the way we get to our property. Okay. As far as Pearson Bridge Road and coming in through different roads, it's that I don't know, but I do know Richmond Hill Drive 100%.
And are your concerns about traffic also related to whether the bridge is constructed or not?
Well, the bridge is definitely the piece that we see as a very, it's the mitigated piece. I mean, when you're building, 1,545 units and traffic is going to go up 10,000, the bridge is very important that they get those permitted, and that to assure the people and Om Sanctuary that that's going to happen.
Okay. And so your concern, again, like Mr. Wilcox, is related to if this bridge isn't constructed, then all of that traffic is going to be funneled down Richmond Hill Drive and impact the congestion on your access point to the facility. Is that a fair summary of your testimony?
That's a fair summary, along with, the safety, of course, for our clientele that would be also added. Because
and is that related to crossing the street from the properties that straddle Richmond Hill Drive?
Yes, it's like until cross it can go with the flow at all. So it's definitely a very big concern too.
Okay. Were there other concerns related to stormwater, just to kind of move things along, that you also had related to the project?
Yes, definitely. Stormwater in the French Broad River. There's a number of reasons why that concerns me and Ohm Sanctuary. Ohm Sanctuary, of course, we, with our mission, it's to introduce healthy lifestyle practices through holistic education and connection to nature. And so the big piece of one of the reasons why people come, it's for those lifestyle practices that are healthy. And the water quality to the French Broad has been incredibly important to Ohm Sanctuary. It's something that we speak about in our, in any of our marketing. It's our location to the French Broad River. And so quality, if we're sending a lot of people out to kayak, tube, and then, if they're going into the water quality is incredibly important.
So you selected, was that part of the consideration for purchasing that property? Was its proximity to the river part of your decision?
Yeah, there was a number of reasons. That was definitely one.
And if I hear you right, you also, as part of the retreat practices at the sanctuary, you all recommend that clients use, or you advertise the use of the French Broad as part of that retreat experience?
Yes, and we also have a section along the river that we do special events, and we've done ceremonial just programming there too.
How long have you been the CEO of Ohm Sanctuary?
I've been the CEO just for a few years, but I was the president for 9 years.
Okay, and what impact does decreased water quality have, in your opinion, as the owner or the lead of the company, on y'all's business to provide retreat services related to the environment and other natural resources?
I would say it has a lot. People who are looking for us, our branding is holistic, which means they expect things to be healthy. And they will definitely want to know what the river quality is for the French Broad. And it's already at a very low rate. So that's just it's a huge concern.
Do you think it will impact people's decision on whether they come to your business or not?
Well, sure. I mean, people who are looking for a place like ours, ultimately a holistic wellness destination, they're Googling and they're looking for these locations that they feel would best suit their healthy lifestyles. So yes, I feel like if our water quality goes down, then, our participation would too.
There was, in talking with Mr. Wilcox, there was a question of, there was a statement that was made essentially saying, well, everybody is going to care about water quality in the French Broad. Is this something that's new to you and Ohm Sanctuary? Is this something that you've been engaging with for a long period of time?
Water quality, yes, we've been engaged personally for years and years. Our family has worked to protect the water quality. We've donated hundreds and thousands of dollars. We've also donated to nonprofits to help preserve lands, to help towns, even like Woodfin in 2005 for watershed quality and other rivers. And so this area has been very important to us, and we have been working for years. It's basically feels like a lifetime. And
is that part of the reason Ohm Sanctuary created the conservancy that's on the nature preserve in order to help protect water quality in the French Broad?
Yes, we feel that we needed to model what we're about, and to model that without, when the trees go down, then the runoff and the stormwater, it's going to pollute the river. We're on high steep banks up there, and so we did in 2015 put the conservancy easement on there.
So that was you all, is that a voluntary thing you all did to protect development on that site?
Yes, we wanted to, when you think holistic, it's you can't be healthy if your environment is poor. It's just a fact.
So your concerns related to stormwater are business related, and that the impact this might have on clientele, if I'm summarizing your testimony, is that correct?
For home sanctuary, yes.
Yeah, and your concern would be related to the impact of stormwater and sedimentation on a water quality issue you and Om Sanctuary have engaged in for, would it be decades at this point?
Definitely. Not Om Sanctuary for decades, but definitely for me and my family.
Okay. And I just want to circle back over a couple issues and I'll bring this all together. Oh, you said you donated, you have donated to organizations that work on water quality like Mountain True in the past. Is that correct?
Yes, and as a matter of fact, Mountain True was one of the first places I wrote and wanted to communicate with when I saw that this development, the size of this development was going in. I spoke to Hartwell and I spoke to some others and asked, what does this mean? Because it's very large, even though yes.
I'm sorry, I didn't mean to cut you off. Go ahead and finish.
Okay, that's okay.
And y'all are members of Mountain True?
We are, have been for a very long time. Decades.
And again, talking about how this is distinct, do you know of any other commercial retreat or entity like you all that does a business like yours related to water quality and interaction with the French Broad, to your knowledge?
Not to my knowledge, no.
And so the damages you all would sustain are different from other businesses or even residential properties?
Yes, I feel we're very different.
Again, you all rely exclusively on Richmond Hill Road, which would be the receiving corridor for traffic if the bridge was not constructed, and that makes you distinct from even people on the other side of Riverside Drive in the town of Woodfin, correct?
Yes, correct. We have no other option.
I'm happy to, I think those are my questions for Ms. Stanback on her special damages and the distinct nature of those. I'm happy for any board questions or to answer any questions the board might have. I think we'd offer the same arguments again that we did related to Mr. Wilcox, slightly different though, and as we cited to the Mangum case where it indicated that the impacts on business were sufficient for special damages. That is unique to to Om Sanctuary and Ms. Stanback's testimony. We think that the damages are distinct again also because of the location on Richmond Hill Drive and the use of Pearson Bridge Road, which are, again, as we pointed out, if you were to draw even a circle that was a whole mile around the proposed development site, that's going to be different from the rest of the community as a whole. And we believe that those create distinct special damages for Om Sanctuary.
Mr. Allen, would you like to be heard?
Sure. I don't have any questions to ask. Just want to point out that that's essentially the same testimony that we heard from Mr. Wilcox related to traffic and related to water quality and stormwater issues. So I think that points out immediately that there's no uniqueness in any injury. In terms of the injury being directly the result of any decision that's rendered tonight, again, there can't be any injury related to that because the things that have been complained of so far with regard to traffic and stormwater are going to happen or not happen regardless of the height of the building. There's not going to be any change to that. We would also further object on lack of expertise and speculative nature of the comments. Other than that, I don't have any comments for the witness.
Mr. Noor, do you have any rebuttal on that issue?
Just briefly, I think Mr. Allen used the word unique versus, I think the case law refers to distinct. I mean, unique would indicate that only maybe one person has it. Distinct, I think, allows for people, it would be a relatively small group, but it doesn't mean that it's only one individual. I mean, these cases aren't, the law on this is not that it's just one person who has damages. It means how are they distinct from the community in general, damages that everybody suffers. Not everybody's running a retreat related to holistic environmental and stress reduction practices, that it was specifically selected because of its proximity to the French Broad River and encourages their clientele to use the river as part of their retreat experience. That makes them very distinct, even for Mr. Wilcox, and how the damages he would sustain. And then in the traffic issue, again, it's a relatively small group of properties that rely exclusively on that road and Pearson Bridge Road compared to the larger community that's outside of that area. So again, I think these damages are distinct, and we'd ask that the board approve standing for home sanctuary.
Yeah, and I would just reiterate the point that these are exact same complaints that Mr. Wilcox had related to the exact same items. The only difference here is that Olm Sanctuary is several properties away on the other side of the hill from Mr. Wilcox, where Mr. Wilcox was directly abutting the property. And again, we think there's no standing here.
So Mr. Nur, you'd be able to back that up with the experts that would testify to the specifics of those damage?
Yes, Mr. Carson and Mr. Finley are on the line. Those are the same experts that we have retained for both of those individuals, and they're prepared to offer testimony related to those damages. Yes, Mr. Chairman.
We intend to do that later on, but right now we're addressing this issue here.
Yeah, we're just trying to be respectful of the board's time and getting through standing before we get to the substance of the case.
Okay.
I did want to say that Mr. Allen just said we are far away, but actually our larger property is only 0.14, I guess that's 240 yards away from the development proposed area. And so I just wanted to clarify that.
Thank you. So can we have a motion that we accept the standing for this witness? Somebody make a motion that we receive her for standing.
I'll make a motion to receive standing. Jay Grimmett.
I second it.
I'll second.
Ms. Lamb. All in favor by order, Mr. Angel, plus sir.
Yes.
Grimmett, yes.
Ken Raza, yes.
Lamb, yes.
Teresa Stoker, yes.
Mr. Noor, your next witness, sir.
Mr. Chairman, our last party for standing is the Mountain True organization. That affidavit was offered by its executive director, Ms. Julie Mayfield. I know Mr. Carson is also on the line, who is an employee of that and has the authority to speak on behalf of the organization as well. Ms. Mayfield has another job that unfortunately keeps her indisposed when she might want to be attending. I know she was planning on and has been on for a portion, I believe, of the hearing, but due to the session being called into order down in Raleigh, I don't know that she was able to stay on for the entire time. So I'm just asking, is Julie on, or we'll proceed with Mr. Carson? I can also ask the board if they'll accept the affidavit that we've submitted, which is a sworn statement for Ms. Mayfield. But her absence is not for any other reason than other pressing governmental business.
We would object to the affidavit unless she's here to be cross-examined.
We'll proceed with Mr. Carson on the same issues. So if Hartwell's on.
Yeah, I'm here.
Thanks, Hartwell. Have you reviewed the affidavit that Ms. Mayfield submitted in support of Mountain True's standing?
I have.
Okay. And can you speak to the same topics that are in that affidavit?
Yes.
Have you reviewed the contents of that affidavit?
Yes, I have.
Would you agree with everything that's in that affidavit as being the basis for Mountain True's standing in this case?
I do, yeah.
I'll go through some of the details for the board's benefit, but unlike Mr. Wilcox and Ohm Sanctuary, Mountain True doesn't own property along the French Broad or abutting the proposed development, correct?
Correct.
Can you tell me what your role with the organization is?
I serve as the French Broad River Keeper.
And what does that mean?
French Broad River Keeper serves as kind of the eyes and ears for the watershed. We look out for water quality issues. We do a significant amount of scientific water quality testing and are constantly working to protect and improve the water quality in the French Broad.
So water quality, is that a core mission component of water in the French Broad? Water quality, is that a mission component for Mountain True?
Absolutely. We have water is a big focus. We have several river keepers that are looking after other watersheds, but my watershed is that I'm charged with is the French Broad.
Is there anyone else who does work like that other than Mountain True for the French Broad watershed?
No, not specific to, not in the scope and depth that we do.
So would you be the leading organization on water quality for that watershed?
Yeah, I would say so.
Okay. And do you all, you expend, what kind of resources does the organization expend on water quality projects in the French Broad?
I mean, water quality is the key component of what we do, and the vast majority of our budget, specifically French Broad Riverkeeper budget, is spent on that. Specific the water quality testing, analysis, education, policy. I mean, that's the core focus of what we do.
Okay, and do you all fundraise on that work? Raise money from donors and members?
We do, yeah, and grants.
Okay. And we heard earlier that the Standbacks and OHM are members of Mountain True. Those resources, what kind of testing you'd mentioned? What kind of testing do you all do on the river?
A big focus of what we do is our E. coli testing. We test weekly, about 30 sites around the French Broad watershed in the summer, but we do a great deal of follow-up testing to try and locate sources of pollution. Sediment testing has also been a key component of the work we do, as well as a variety of other testing and issues as they arrive. But I would say sediment and E. coli are the kind of the backbone of our work. And the reason
sorry, go ahead.
I was just saying the reason is those are our two biggest pollution sources.
Okay. And do you test in the area of the proposed development?
We do. We've done, I mean, our most extensive testing site right now is probably the Pearson Bridge site on the French Broad River.
Okay. And are we talking, 10 tests? Are we talking thousands? What are we talking about here for the testing within the watershed?
Throughout the watershed, thousands. I mean, and at Pearson Bridge, we're probably talking hundreds because we're working on a special project there.
When Mountain True saw the plans for this proposal, what concerns did you all have out of stormwater?
The concerns were the size and scope of the project, as well as the location. I mean, all of those factor in to make this a very high-risk project, in my opinion. Putting that many units, that much impervious surface on a site that is as steep as it is and as close to as many water sources as it is raises a lot of red flags.
And what do your members or the supporters of Mountain True, do they regularly recreate on the French Broad in this area?
They do. We built and opened the French Broad paddle trail, so that's a real economic driver for the river. But recreation on the French Broad River has exploded in the last 10 years, as anybody around here knows, and has become a very popular destination for tourists and locals alike.
And is there, across from this proposed development where the bridge is proposed to land, is there a particular recreational amenity that's proposed for the French Broad in that location?
Yeah, the Greenways and the Woodfin Wave are a project I commend the town of Woodfin on for pursuing in an effort to bring folks down to the river. And the reason we're supportive is to bring those folks down in hopes that they'll want to protect and improve the water quality in the French Broad.
And is Mountain True a partner in that effort to bring that into fruition?
We are, yeah.
And do you have concerns about people recreating in the area related to this development in the stormwater?
I do. I mean, the water quality of the French Broad is tenuous. It can be clean and it can be dirty depending on any given sampling period and largely related to weather events. But this section of the river, the water quality data has been concerning and has gotten more concerning over the last several years.
And just for the benefit here of the board, do you have any specialized training or credentials that allow you to reach that assessment or the conclusion?
Yeah, I have a undergraduate and master's of science in resource management, and have spent the last 15 years as the French Broad River Keeper. We've designed the testing protocol that we use, which is based on EPA certified quality assurance protocol. We vetted that testing with this North Carolina Department of Environmental Quality to ensure its accuracy and integrity. And we've trained hundreds of volunteers in our testing protocols.
And based on your review of the proposed development, do you believe that the stormwater is being adequately addressed as proper drainage as provided under the ordinance being provided in order to address the stormwater you anticipate coming from this development?
I don't think enough evidence has been presented to make an assessment, and I think that's an important consideration. Right now, the plan is extremely lacking in detail to assess that, but the size and the scope and the steepness and the water on the property make a development of the size very concerning, particularly without a lot of information to show that it won't impact the French Broad River.
And is that based, do you draw that conclusion based on your experience with other similar developments?
Yeah, we've monitored, dozens of developments of a similar scope and hundreds of developments of a smaller scope, and have seen stormwater as our biggest pollution source. And the reason the French Broad is impacted and impaired in this section of river is stormwater runoff from developments. There's plenty of scientific literature that backs up as you take a pervious area such as a forest and pave it over with impervious, water quality declines.
And would does Mountain True, do you all apply for grants to improve water quality in the French Broad Basin?
We do.
And if I'm hearing you correctly, you believe that this development, it's your opinion that this development doesn't adequately control for stormwater. Would you all, would that require you all to divert resources from your budget to address issues here that you're otherwise spending in different places? Is that a potential outcome of this?
Yeah, certainly. We're certainly concerned as pollution sources pop up, or potential pollution sources. We want to keep as close an eye as possible on those issues. And this section of the French Broad River is particularly critical because of its high recreation value and high recreation use.
And what impact would the increased stormwater have? I think it's sedimentation you mentioned, have on the, you've been working to improve water quality in the French Broad, correct?
Correct.
So what impact would this have on those efforts that you've been engaged in, or the organization has been engaged in for years?
Sediment's the biggest pollution source across the country, and the biggest pollution source in the French Broad River. Sediment smothers aquatic habitat, it suffocates fish, it clogs fish gills, but it also delivers a lot more harmful pollutants like bacteria and nutrients, and heavy metals are attached to sediment. So essentially sediment is a vehicle to deliver pollutants to the French Broad watershed. And that's why when you see the river buddy, that is a good indicator of not only sediment pollution, but usually E. coli and other pollutants are in the water as well.
Okay. And I did just receive a text that Ms. Mayfield is signing on. So I might ask if board members have any questions. I'm sure she can join. Maybe she's already come on.
Just to substantiate her affidavit.
Correct. But I guess in summary, Hartwell, Mountain True is essentially the leading organization on water quality in the French Broad, correct?
Correct. And
there's nobody, that makes you all distinct and unique from any other organization that's related to that water body, correct?
Correct.
Okay. And so these damages that we've talked about essentially threaten to undermine the mission of the organization that leads those efforts in the French Broad.
Correct.
Okay. And again, I'll just ask if Julie's available. I know she is trying. She's actually asking me for the link. So I don't know if the board needs maybe a brief 5 or 10-minute break for convenience. I know we've been going at it for a little while, but I'm sure I can get that to her and then she'll be on by the time you would return. But I'll do whatever the board would like.
That would be good, Mr. Noor, because then Mr. Allen could go ahead and ask her questions if he wants to. So we'll
Okay.
take a break until Mr. Noor can get Ms. Mayfield on the line.
Guess nothing for me.
Information that is being a discussion off the record, which you can't have in this hearing. Perfectly good questions, but when the meeting opens back up, then obviously the applicant will be the one to ask those questions. But you need to get all the discussion on the public record.
Yeah. We're going to get to that.
Thank you, sir.
Thank you, Mrs. Can I get you that?
Julie, have you been able to log on yet? Just checking in. Okay. I'll just say, Eric, it appears, it says they're waiting to let someone, she's waiting to be let in. If someone could help with that.
Oh, yes. I was not noticed yet that we thought this was going to get filled. We weren't able to get to this meeting because of that.
Careful, don't hit your head.
No, yeah, that's good. That's what I thought we were going to start off with.
Yeah.
But it is.
Sitting here, I thought, wait a minute.
Yeah. It's a legal thing. It's one of the legal issues.
So
that,
we should not really have accepted this.
oh, you can accept them as witnesses, but it's just like It's one of those, like runs on a ladder. If you say, I object to this, okay, noted, we will continue. But it's in his favor to go ahead and get these people.
Well, I know.
Yeah. Yeah, they didn't bring it up.
No.
I thought that would be the first thing.
Yeah.
Ron, I'll just put out there, I think Julie was trying to get in and it was saying they needed someone to let her in. So maybe that's just on the access. I know she's going to try again.
You let Miss Mayfield in? There she is. She's joining.
Before we get started, I'd like to request of the board that if possible, the chat feature be turned back on, allowing the most voices to be heard and recorded at this public hearing.
And this is a quasi judicial hearing. Everybody who testifies is presumed to be under oath. These chats are by people putting in information that if the board wants at some point to treat that as witnesses testifying, fine. But as attorney for the board, I recommend against random statements coming in, becoming part of the record. If this was the planning board, if you were acting your legislative hat, yeah, you'd want all these things. But you're wearing your quasi judicial hat tonight, so you want all of the information that comes to you funneled through that testimony process, where each comment coming in, somebody is in a position to cross-examine those. And the chat feature just contradicts the function of in a quasi-judicial hearing. I know you hate
I
this,
see.
but it gets things in the record that don't get verified, don't get cross-examined.
I see. Thank you for your response, sir.
I'm afraid it'd be problematic down the road if all those chats are in the record.
Yeah, I understand.
Okay, Mr. Chairman and board members, I think Julie is on and can answer questions. I think we've pretty much gone all the way through her affidavit, so I don't want to replow the same ground that we covered with Mr. Carson. But I will just ask Julie quickly as I put this up on the screen. Ms. Mayfield, is this your affidavit? Can you see on the screen where I've thrown up the affidavit of Julie Mayfield?
Hello, everyone. I apologize. I am in my car. I am going to pull into a parking lot. Oh, so now I can see it. If you hang on 1 second, I will park. I apologize. Yes, I can see it. And yes, this is my
This is your affidavit. And are these your signatures on the last 2 pages here?
Yes.
Okay. Without going into the detail, these are, there's a sworn statement. It's true and accurate. Nothing has changed since you signed this document, correct?
No, it has not.
Okay. And I will just ask, Mr. Carson talked about this, but Mountain True, part of its mission is water quality, is specifically in the French Broad watershed. Is that correct, Ms. Mayfield?
That is correct. Yes,
And
we have an entire program dedicated to that.
And I'd also ask that if sedimentation and stormwater damages were sustained as a result of the project, if that would divert funds that Mountain True uses in other areas related to water quality, if that could divert those funds to dealing with these kind of damages. Is that a possibility?
Yes.
Okay. I'm happy, I'm going to stop sharing there. Happy to have the board ask any questions that might have. And then I do have a little bit of argument that's different because of the associational nature of this applicant versus the other two.
Does anybody on the board have any other questions for Ms. Mayfield? And we just wanted to make sure that she attested to the authenticity of her affidavit.
Okay, and I know Mr. Allen had mentioned maybe he had questions for cross-examination. I didn't want to pass by him.
Do you want to give Mr. Allen a chance now? For him?
Sure. Thanks. Ms. Mayfield, can you tell me about the general programming for Mountain True, please?
The general programming of the entire organization?
Yes, ma'am.
Sure. Sure. We are a regional environmental advocacy group. We focus on the mountains of Western North Carolina and 2 counties in North Georgia. Our primary program areas are water quality, public lands, healthy communities, and clean energy. And we have offices in Asheville, Boone, Hendersonville, and Murphy.
Okay. Thank you. That's all I have.
Just for the board's benefit, this is slightly different than the last 2 applicants we've had, and I'm going to throw something up on the associational standing. Associations can have standing like persons can. And so what's required in those situations is that its members, some of its members might be able to, it has standing if its members would have standing. And as we've already heard, Ms. Stanback testified to that, and the board has concluded that standing was appropriate for Ohm Sanctuary. So we've met that first threshold. The second relates to the interests that it's seeking to protect being germane to the organization's purpose. And so, as we've also heard from Mr. Carson and Ms. Mayfield's affidavit, we see that Mountain True, one of its core mission components is water quality in the French Broad River and that water basin, and that the concerns of stormwater and sedimentation discharges that would be coming off of this proposed development relate directly to the organizational purpose for Mountain True. So that second criteria has been met. And then lastly, the law points out that standing is appropriate so long as you wouldn't need all of the other members or other members of the organization to be part of the lawsuit as well, or in this case, the quasi-judicial proceeding. And that's also been met in this case, in that members of Mountain True could be parties theoretically if they could show the special damages, but they're not required to be here. They don't have to be a part of this proceeding in order for Mountain True to represent those members' interests. We've also heard specifically about the damages that would be sustained by the organization as a result of the proposed development, and that the concerns are related again to an operational core component of who they are as an organization. So we would say, again, this organization is distinct from, as Mr. Carson pointed out, any other organization that works in this field related to the French Broad, and we think that that provides the special damages necessary for associational standing for Mountain True. I'd also point out that under 160D 1402C, the law provides as a C3 that it includes kind of homeowners associations, but also other associations that are organized to protect and foster the interest of a particular neighborhood or local area. And I think Mountain True falls into that category as well, related to the French Broad as being a location that has a physical presence in Western North Carolina, and that their mission is tied to that. And happy to answer any questions the board might have.
Mr. Allen, do you have any rebuttal to that?
Sure. I'll start with the same objections that we've had on the first 2. And again, we're back to the exact same concerns regarding, at least regarding stormwater. And this is being echoed again. We think that's a general concern. The second part is it's not damage in this case, because any stormwater impact is going to happen no matter what happens with the decision this evening. And the third is a continuation here of what we've seen. One was the property owner right beside the property. The next one was a business that was several properties over. And now we've got an entity that is not a property owner, but is an association. And I will agree with Mr. Noor in that it has to show that one of its members would have standing. I agree with that part. But then it also has a part that says that you have to be formed to promote a local area. Here, you heard Ms. Mayfield say that this is a regional endeavor, the Western North Carolina region, including Georgia. It's not a local area. It doesn't qualify under the section of 160D. And for all of the reasons that I mentioned previously, in this new reason with respect to the association, it's not a local area organization. It's regional association and therefore has no standing under that basis as well.
Mr. Nora?
I just briefly respond that, while it is regional in scope, it has particular emphasis and core mission components on the French Broad watershed, and they do testing specifically in the area where this proposed development is located. And so, they maybe be an organization that has as an organization a broader scope, but one of its particular components is focused on the French Broad in this area and already has documented work in that area for water quality testing. And I think that meets that
Specifically the Pearson Bridge area.
That's correct.
And we'd point out that that's no different than the state doing it or the federal doing it. So if you looked at these little items of bigger organizations, all of them would qualify, but that's not what standing is about. Here, it's very clearly, by their own words, a regional organization to promote regional items. I just happen to do work in our area.
I would just add, and Mr. Carson can testify to this, they actually do some of the measurement for the state. I don't want to overstate it, but Mr. Carson might be able to elaborate if there's concern about their role in that as being duplicative. I think they are actually a unique organization that provides that. But I'll ask Hartwell if he could elaborate.
Yeah, I'll add two things to that. One, the state does some testing in the French Broad watershed. We do dramatically more testing. We also are partnering with the state on a project to correlate turbidity and E. coli at Pearson Bridge on the French Broad River. So we have, that's why we've invested such significant amount of time and resources at that location. And the last thing I would add is this is not my field of expertise, but we have at least a decade of experience working in the Richmond Hill Park on water quality and non-native invasive species. So we do have a long history in that exact area, including work on the Alm Sanctuary property as well.
I wouldn't have any other arguments to make in support of the application, Mr. Chairman.
Thank you, gentlemen. Somebody like to make a motion on the standing of Mountain True in this matter? Somebody like to make a motion that we accept them as a standing right member?
I'll make the motion that we accept them as a standing
Standing right.
standing right. Can I add a comment?
Sure.
My only comment is that, Mr. Noor, all of your witnesses objected to this meeting being held remotely, and they were all checked on their applications. So just an FYI.
We were going to raise that issue with the board after standing was established because that has some special significance for the meeting as a whole. I had not forgotten about that, but wanted to address it after the board had reached its decision on standing.
My motion stands.
Somebody second it?
I second it. Grimmett?
Roll call, Mr. Angel?
Yes.
Grimmett, yes.
Raza, yes.
Lamb, yes.
Stoker, yes.
Those are my clients who've applied for standing, Mr. Chair. There may be others, but those are the only ones I represent.
For this evening?
For this evening, correct.
Okay. Did you want to speak to that issue, or is there a later time that would be sufficient to?
That might be appropriate now as well, now that the board has voted on standing. And I will, if you'll give me a second, Mr. Chair. And forgive me, I missed the board member's name who raised the issue about the remote meetings just previously. Forgive me, I didn't catch your last name.
Stoker.
Ms. Stoker, I apologize. As Ms. Stoker pointed out, on our applications for standing, we had noted that we objected and did not provide consent to the remote hearing process. And what I'd like to do at this point is throw up the statute related to that for quasi-judicial hearings. And that statute says that a public body may conduct a quasi-judicial proceeding as a remote meeting only when all of the following apply. And the second one there is all persons subject to the quasi-judicial proceeding who have standing to participate in the quasi-judicial hearing have been given notice of the quasi-judicial hearing and consent to the remote meeting. And again, it defines further down what remote meeting is. And it says an official meeting or any part thereof. So it could be a component, but not all of it, between one or all of the members of the public body, that would be all of you all on the Board of Adjustment, participating by simultaneous communication. And then simultaneous communication is defined as any communication by conference telephone, conference video, or other electronic means. And so conference video would include Zoom. I think other electronic means would include Zoom. And so at this point, we would say now that the board, while we objected in our applications, and I'm happy to throw that statute back up if it would be helpful for the board, or if it would be assistive to Mr. Allen when he makes his argument. At this point, we do object, and we have not provided our consent to the use of a remote meeting, which is what this is. And so we don't think that it could continue on to the substance of the quasi-judicial hearing absent that consent. And so we'd ask that this meeting be, I think best is, I would be open to interpretation on this point and saying whether it needs to be continued or whether it needs to be adjourned until that consent can be obtained, or the emergency, the declaration of emergency that created the ability to use this format is rescinded. And would ask that the board continue that until that can be achieved, and then a full public process that is safe can be engaged on. I think as of right now, I'm looking at a gallery view of over 100 individuals who have engaged in this process through the Zoom interface. As of right now, there's significant public interest. And while I think I have a hard time seeing you all as I'm presenting, and I don't know if you have the same difficulties with me, we believe that this decision is best served to be made in the typical open public meeting format that allows for the community to engage in person and not just remotely. And we'd ask that this be adjourned or continued until that consent for the need for the emergency goes away. Happy to answer any questions the board might have.
Mr. Allen, do you need to speak to that, sir?
Sure. I'm having deja vu all over again with this. Mr. Knorr and I litigated this exact issue for a good 6 weeks in a Buncombe County matter. And in fact, the notice of hearing and the format that's set out that we're participating in this evening was part of that lawsuit and went through and with approval by a Superior Court judge. So we've actually gone through this. I would ask Mr. Norphy to put that statute back up, if you can get that on there, John.
Yep, 1 second. Is that up there, Derek?
It is. I appreciate that. And what this turns on and what we believe is what a remote meeting is. And a remote meeting, if you look at that, is defined as an official meeting with between one and all of the members of the board by simultaneous communication, which is what you have here. You don't have here. Here you have all of your Planning and Zoning Board of Adjustment members in the same place with access to screens and access to immediate communications from one another. The only folks that are participating via Zoom are those folks who aren't part of the board. And that's what the court was presented with those arguments. And that's where the court decided that we would go forward in that Buncombe County matter. And we went forward with a hearing format that's exactly like the one we're participating in tonight. We can all share our screens. In fact, I can make the argument that not only is it safer, I think that's obvious, in this time period, but allows us to continue due process concerns. It allows us to resolve very important matters. But in a lot of respects, it's better than in-person hearings. I can see these documents. I just asked John to share this screen. I can see exactly what he was talking about with the highlighting pieces, and all 100 people, whoever's participating right now, can see them exactly at the same time. There's no reason to jam a room full of a lot of folks in a time that's going to be super unsafe in order to twist the plain meaning of this remote meeting to mean something different than it does. You've set up with the help of your planning staff and your attorneys a proper format, one that's already been vetted in a very long lawsuit and approved by a Superior Court judge in Buncombe County, in a format that we believe works and is fair, protects both due process as well as people's ability to be heard in a practical manner.
Mr. Noor, all of our members except for one are present in the building at this time. I don't know if you knew that or not, but all of our members that would vote are present, with the exception of one person who had her COVID shot today and just couldn't make it.
So just, I appreciate knowing that, Mr. Chairman. I'm happy to let Mr. Sneed look like he was about to say something, so I don't want to interrupt him.
Just in case it wasn't clear, the one who's not present is not participating. They have 6 in the room. And that at the moment with the vacancy, this is a 6-member board.
Okay, so I have a brief response to Mr. Allen's argument, and that is, I don't think he was intentionally trying to say it maybe the way he did, but what we have had is there has not been a judge that has, I don't believe, has approved this process. There was a lawsuit that challenged the process, and the court denied an injunction related to that. There has not been a order or decree that looks at this process or the similar one used by Buncombe County and says that complies with open meetings law. That has not occurred to my knowledge. And then again, I think the board can look, and I will throw up that statute again. You can read for yourself. An official meeting or any part thereof where you all are using participating by simultaneous communication, and the communication means conference video. And so let me give an illustration of the part thereof. When you all hear me, you're using simultaneous communication to hear me, receive argument from me, receive testimony from those who provided affidavits and already spoke, hear from our experts. You all may be sitting in the room together, but you could not conduct this meeting without the simultaneous communication that is facilitated by the Zoom interface in order to hear the testimony that you're receiving. Otherwise, you'd just be sitting in a room by yourselves. And so that's the part thereof in which you're using video conferencing. And so again, the purpose of this statute, and I think that's relevant too, was to allow for, non-controversial projects that needed to move forward to do so, because the default is not remote meetings. The default is in person, and we're not asking for that either. What we're asking for is for this to be done in a safe way when appropriate. And the other part, and as illustrated earlier tonight, we'd like to be able, this is the first time we've been able to see the interface through which you all see us, hear us. And so maybe there's a way between now and a subsequent meeting where we can be assured of the quality of the connections, at least from a due process standpoint, to extend our consent to this kind of meeting being used. I've done both. I've had clients that were fine with it and others that had concerns about it. And so these clients have concerns about the engagement process and the due process rights and have objected. And so we would renew our objection, ask the board continue it, but are otherwise ready to proceed tonight if it should choose to do that. But we don't think that you can comply with the public meetings law without our consent.
Mr. Sneed, do you have some advice as to the challenges, the legal challenges that may be pending in Superior Court or other courts?
I have no information on the cases pending Superior Court or other courts. The only thing I could add to the conversation is that the School of Government basically agrees with Mr. Allen's interpretation.
Okay. Well, Mr. Noor, how about we'll continue with our process, and if it looks like we're going to run into a wall or something where you feel like as if it's challenging your side of the story, if you bring it to our attention, we'll try to renegotiate what to do. But I think we can continue on at this point and try to get Mr. Allen's side, or if there's any other business that you have concerning standing rights, then we'll hear you, continue to hear your issues. We'll continue on, but if you feel, or Mr. Allen feels like there's something that needs to be reviewed by a higher court, that'll work.
We would just ask that maybe a vote from the board to proceed would be made for the record so that we have that recorded.
That'd be fine. Somebody make a motion that we continue with the process, and if there is some question, we will stop at that point. Somebody make a motion.
Jeff Angel make that motion.
Somebody second that.
I'll second that.
Okay. Take a vote. Mr. Angel?
Yes.
Okay.
Grimmett, yes.
Raza, yes.
Lamb, yes.
Stoker, yes.
And I have no other parties that have applied for standing, Mr. Chairman.
Okay. Thank you. Mr. Allen?
I had one clarification. You said there were 6 members that were present together.
Yes, sir. There's
And-
one in the back. It's Mr. Malling.
Okay. And the 7th member is not participating in this deliberation, correct?
Yes, she had her COVID shot, and she felt like she was having some after effects of the shot, and she couldn't make it tonight. So Mr. Malling is an alternate, and he is inside the building at this time.
Excellent. Well, and I think that's the right result. And I think Mr. Noor and I have different recollections of what happened with the hearing. The hearing did go forward with this format, and I think that we can do it in a fair manner. And I believe now's the time, if the board agrees for us to present our case in chief, unless there are other items of standing that need to be determined. And I'll leave that to the board chair.
No, I think, Mr. Allen, I think it's your turn.
This parcel, 82 acres, and when it was applied for, it included another 10-acre parcel. And this project was originally being discussed as early as 2019 with the town. This property, Mr. Peterson is the owner of this property. The property has been zoned Mountain Village as its zoning designation for years. Mountain Village has allowed 17 units per acre for multifamily and a host of other uses that are both permitted and conditional use permitted inside of the original zoning for Mountain Village. In addition to the Mountain Village zoning, this particular parcel was designated as an opportunity zone area. And opportunity zone areas, just to give you a primer on that, it's designed to spur economic development in the land. It provides actual tax incentives to investors to invest capital for development in property. It is not designed for passive ownership of property. It's designed for folks to put money into improved property. And so this property has been represented to the world and to neighbors moving in and neighbors that live there as an area that would be developed along the river for some qualifying opportunity zone use inside of Mountain Village. And that's a long precursor into where we are. The original project application in December included multifamily that is still part of the project. In addition, and at the request of previous planning personnel at the town, the developer, my client John Holsworth, had included other uses, including hotel uses, some light retail uses, office uses, but they are all part of this multifamily project. And that was always the part that was pushing forward. As we started to look at this permit application and this thing started to become public, we realized that the multifamily needed to stand on its own. And quite frankly, it seemed to be the easiest part of the project to permit because multifamily in Mountain Village is an allowed use. But for the fact that we have this 35-foot height issue that you've already heard a lot about and you'll hear more about, But for that, we would not be in front of this Planning and Zoning Board of Adjustment. The development could go forward at 17 units an acre, multifamily properties with 3-story buildings. We'd have to figure out how to measure the 3-story buildings, but we could work through that. But 35 feet and below is typically going to be a 3-story building. And we believe that is as of right development that we could do right now. And one of the big parts here and the head scratcher is opposition coming from folks like Riverkeeper, coming from folks who talk about stormwater runoff. And by all accounts, in simple math, the smaller buildings that are taller are going to have a smaller footprint for impervious surface. The smaller buildings that are taller are going to create more stormwater. These smaller buildings that are taller are not going to create any more density, they're going to create any more traffic trips. They're all going to be the same. The 82 units and the 82 acres at 17 units an acre is going to produce 1,394 units, and it can be in 3-story buildings or 5-story buildings. The only thing, and I want to make this point as clear as possible, the only thing that we're asking this board for is to exceed 35 feet in height to have those taller buildings. That allows us to reserve more open space. It allows us to stay away from the river. It allows us to have more recreational areas. It allows us to do a better, more responsible development. At this time, I'd like to introduce my first witness. My first witness is John Holsworth, who's the developer in this property, and I'll turn it over to John now. John, I'll swear you in.
Okay.
Chair, did you swear as a witness? Do you solemnly swear that the facts you give tonight are true to the best of your knowledge?
I do.
Okay.
John, can you introduce yourself and tell us a little bit about your background?
Sure. John Holsworth. I have a home in Burnsville for the last 17 years, as well as a home in Florida. I've been in the multifamily business, developing, managing existing, brokering for 45 years. I've owned my own company for 23 years. I've worked for Trammell Crow down in Miami, Cardinal Industries, and some private owners.
Mr. Holsworth, can you describe the differences that will be in the development if it's developed as 3 stories versus 5 stories?
Well, the property, as everybody realizes, I think is pretty unique with the trees, the location. And what we aggressively tried to do was to keep as many of the trees as possible. So we engaged an architectural firm out of Orlando, and we brought into North Carolina a type of building that has never been done up here, which is called a Texas donut. And basically what that does, it puts the parking garage for all 5 stories within the building, and you will not see the parking garage, and you will actually park at the same level as your home. By doing this, we've eliminated all the surface parking that normally surrounds multifamily homes, which what that does is gives a tremendous amount more of green space or trees to the site itself. You know, one of the things I personally did is I walked the entire site, as some of you may know. I spent 2 days doing that. It's not a typical site, and by walking it, we were able to get a clear idea of where the best location for these 7 buildings could be with the least effect on the environment. And so we came up with these 7 locations.
John, if this request to exceed 35 feet is turned down and you're forced to do the 3-story version, will the parking be internal in garages or it be surface parking?
Most likely it will be surface parking to accommodate the way the buildings have to be built, and thereby reducing the amount of area that would be open or green space. Right now, by doing the 5-story, we believe that it's close to 40 acres of upland that we're not going to have to touch out of the 82 acres. If we go to the 3-story structured with surface parking, If you're lucky, you may get 10 or 15 acres of open space.
In terms of the number of units, with the three-story version of this project have the same, less than, or more units than the five-story version we're asking for.
They're both identical.
In terms of ingress and egress that has been proposed, will there be any differences with the ingress and egress between the three-story version and five-story version?
From leaving the site now.
In terms of stormwater that is generated, would a three-story version produce more stormwater or less stormwater that has to be managed than the five-story version?
Just for the record, object to the foundation not being laid for expertise in the area of stormwater. If he's going to be testifying on traffic and stormwater impacts, I think a foundation has to be provided for his expertise in those areas.
Can I add something to that? I'm a licensed contractor in Florida and have been for over 30 years.
Based on expert testimony that we'll put in later, stormwater effects on the property, will there be greater stormwater that has to be managed with three-story buildings or five-story buildings?
Again, we review our objection on the basis of establishing expertise in the areas of stormwater, and ask I think he needs to be qualified as an expert in stormwater if he's going to provide opinion testimony on that topic. We ask the board to rule on that objection.
Mr. Allen, you have a witness that would be able to testify as to these issues?
We do.
Okay, good. So can we go on to the next question?
We can. I think this is a good time to relinquish this witness. If there's any cross-exam from Mr. Noor before we call our next witness.
I just have one question, John. When there's some confusion as the number of structures or there's one number that's 1545, and then there's another number of 1394. Which one are we working with? Because the 1394 is 13 per.
1394 is the number. It's 82 acres times 17.
Right, with 17 units per acre.
Correct.
But we have some information here that's 1545, which means it's 18.8 structures per acre. So you're saying the 1394 is what you're going with?
Exactly.
Okay, not the 1545 not to be included.
The 1545 number comes from the original project application that included an additional approximate 10 acres. As that was taken out, the density, the allowable units goes down because it's less acreage to spread the density across.
Right, I was just looking at both. 1545 had still been included in some of our documentation. I just want to say that we're going to stay at 1394 for 82 acres, just to clarify that fact.
Correct.
Okay, that's all.
I do have a few questions for Mr. Holdsworth. Mr. Holdsworth, are you currently under, is it you who's purchasing the property, or is it a business entity that you own that will be purchasing it?
Ultimately, it'll be a business.
But who's closing on the purchase of the property as of now?
It'll be the business that will be closing on the property, which is a Delaware corporation.
Okay. And is that company currently under contract to purchase the property?
Not yet.
So are you at all, is any entity under contract to purchase the property?
I am, and I have the ability to assign it.
Okay, so you personally have it under contract to purchase?
Correct.
Okay. And you submitted the application with the current owner's consent to do so for the property?
Correct.
Okay. You'd mentioned, I do want to throw up, just give me a moment. I just want to pull up one of the documents that we've seen this evening. Okay. Okay, this is the revised site plan form on the lower left-hand corner. I believe this is the same document Mr. Allen threw up earlier, and I think the board chair just asked question that I think is important here. So I want to clarify, your project proposal is for 1,394 units, not 1,545, correct?
That's correct.
Okay, and so these documents that you submitted to the town that depict, and I'm looking in the lower right-hand corner here that says 1,545 units, 5-story apartment, that is not correct. That would not be an accurate representation of what you're proposing at this point.
Correct.
Okay, and that would be the same here where it says 3-story apartments, 1,545 units. That is no longer accurate based on the testimony you've given tonight, correct?
Correct.
Okay, so have you submitted that change in writing, or is this the first time that this has been given to staff to let them know that the size of the development has changed?
I believe the original change was back in December at the 1394 when we did not bring in the 10 acres. The 10 acres was supposed to have been annexed in and zoned back in November.
Well, I'll point you to, again, this says January 26th, 2021 in the lower right-hand corner. So this wouldn't be back in December. This was at the end of January that this was submitted to the town, correct?
Correct.
Okay, so this submission has 1,545. You're now proposing something with 1,394. These drawings no longer accurately reflect that. And I guess we might be able to ask Ms. Eisenhower whether the town received anything in writing indicating the change in the plans prior to this evening.
Objection, it mischaracterizes the testimony. The application is the application, and the application is for a variance in height. And we made it clear in the application and the follow-up materials submitted to the town that the drawings were for illustrative purposes only, and only are there to illustrate what that density would look like. The density is what the density is, and the Mountain Village requirements are what they are. And the Mountain Village requirements dictate that a master plan has to be submitted before development can move forward. That is not what we're talking about here. So any detailed questions about an illustrative diagram really are outside the scope of the current application. The current application is going only to asking to exceed 35 feet in height for the buildings. And these drawings that you're referring to and that are included in the application do nothing more than illustrate what the density looks like under those acreages.
Well, just briefly in response, I'm not trying to be difficult. I'm just trying to understand how this change happened and when that occurred. And the documents say what they say, and they were submitted by the applicant to the town. So I just want to make sure that we have that in writing, that change has occurred, and so that we're, locking that in. This is no longer 1545, and that these documents that have been submitted by the applicant no longer are accurate in reflecting the proposed project. I'll move on to another question. Have you, in your career, have you ever developed a project like this on property with the kind of slope that we're dealing with on this piece of property?
Not that slope, correct. But the location as far as being a flat area and not putting it on the slope itself, yes.
So, and at this point, have you done, and I'm just going to stop sharing my screen for a second. Have you any stormwater management plan? Have you done that, completed that process for this proposed development?
Not as of yet.
Okay. And you testified earlier that you had looked at the property, walked it, and wanted I might muddle this. I don't want to mischaracterize what your testimony was, but you said you wanted to incorporate components that were environmentally sustainable, or what was that exactly? If you could rephrase for the board, just in my memory too.
Well, we wanted to have the least impact on the slopes on the site where the buildings were planning to go.
Okay. And what analysis did you perform in order to determine whether your proposed development would have the least impact?
We looked at the site when we prepared the site for the building, and actually those buildings are pretty much designed individually to support the flat area once the property is graded at the top.
but was there any analysis in comparing the proposed development to what would be best management practices from a sustainability or an environmental impact standpoint?
Same objection. This goes well beyond the scope of this particular application. To reiterate again, the sketches that have been submitted are for illustrative purposes only, reflecting only the density. And the only issue that's being proposed right now is the increase in height. The items that are being asked by opposing counsel currently are all items that will be covered in the master plan that's required in Mountain Village. And that master sketch plan is a requirement of the development process and well outside of the current conditional use permit request, which only asks to exceed 35 feet. The items that are being asked right now of this witness are fundamental before those items can even be done in terms of the stormwater management plans and the detailed drawings.
If I can respond just briefly, I'm asking questions related to stormwater. And again, I'll throw up for the board what it's already received this evening is the worksheet that it will have to look at to determine whether this meets the conditional use permit standards. One of them explicitly includes specific evidence concerning stormwater. And so my questions have related to whether that work has been done and whether evidence will be presented showing that adequate utilities, stormwater infrastructure would be a utility, drainage, that would be covered by stormwater infrastructure and other necessary facilities. So I think my questions are directly related to the standards the board is going to have to evaluate. Additionally, the witness had testified that he'd gone through the property and attempted to make it as low an impact on the environment or on the slope as possible. And I was asking about what analysis was done to achieve that result in order to understand his testimony more fully. So I think the witness should be required to answer the question. I'm happy to re-ask it.
Yeah, and for the second or third time now, none of these requirements in 54-255 apply as part of this consideration. Every single one of these conditions looks at a conditional use. The very first sentence of 54-255 says the following conditions will apply to all uses listed as conditional in the permitted use table. Exceeding the height of 35 feet is not listed in any table. It's certainly not listed in the permitted use table. It's not a conditional use. It's just a quirk of this ordinance that we're in front of this board right now. None of these elements, these 7 elements apply. And I think it's a good time to have the board rule on that, because I think we're going to run into this issue with every single witness because that worksheet, and we can take time to go through it, that worksheet simply doesn't apply to a consideration of height. Your ordinance in the town of Woodfin already sets out what's required to exceed 35 feet in height, and it's not the 54-255 conditions.
We obviously disagree. I mean, the standard that I think Mr. Sneed cited to the board during your training said that buildings in excess of 35 feet in height have to go through conditional use permit approval. And those are the standards that I've been citing to that are on the worksheet that you all regularly use for a conditional use permit. And so we believe this applicant, like every other applicant that applies and has to go through conditional use permit approval, has to present evidence that shows compliance with those standards. And essentially what this is the 35 feet height triggered the review that we're going through. But it doesn't mean that that's the only issue this board looks at. Otherwise, you'd have to ignore all of the statute that lists out the conditional use permit requirements. And the provision that's referenced by Mr. Allen related to the fire chief's approval, that is one component related to height, but it's not the only component, and nor does the ordinance say that. And so, again, we think the burden is on the applicant to produce evidence that shows compliance with each of these standards, and that's why we're asking questions related to those standards.
And I would appeal to the chair to determine which of these apply, because 54-255 very clearly says that these conditions apply to all uses listed as conditional in the permitted use table. And there's a difference between applying those standards and going through the conditional use permit process. We're going through the process, but these standards in 54-255 do not apply by the very terms of 255.
Mr. Allen, since this is a hearing for a conditional use, these are the guidelines that we have been given to go by on conditional use. If you want to pause our public meeting for us to receive some additional legal definition as to which way we should go, we can do that. If you want to have, address your witness on the fire chief, if you want to continue that, but I believe we need to go ahead and get a ruling on this particular issue if we're going to go any further, because that'll give you a chance to go ahead and call witnesses that could talk to stormwater and those other issues Mr. Nor has brought up, if that should be the decision that we take.
I'm not sure I understand the choice here, and
I think we need to get a legal decision or at least some legal advice on what we're going to do with our conditional use requirements that we have been given on our worksheet as compared to just looking at the height of the structure to get a better assessment of what's this development going to be like and what impact is it going to have on the particular area. So I think, I'll give you the choice. We can adjourn our, or just suspend our meeting at this point while we get some legal clarification. What do you think, Mr. Sneed?
Well, I wouldn't call it suspending the meeting, but you can pause for a minute and
That's what I
ask
was trying to get at.
counsel, and I can reiterate what I told you in the workshop we had earlier. And you do have some, and I told you this decision point might come.
Yeah.
Just as a literalist, if you read the ordinance, and as I told you at a workshop, I went through looking for what standards, for conditional use, it usually comes with conditions. And those are quite often subjective, sometimes objective. And for most conditional uses that you have, it'll be an example I use, which isn't even in your ordinance. For a nursing home, there'll be a set of conditions you have to meet, and those are specific. In this case, you've got one section from which your worksheet is taken. This is the one they're discussing. Mr. Allen's saying it doesn't apply because the lead into that says only those conditional uses listed in your permitted use table, so it doesn't apply anywhere else. Of course, have them not apply at all and have a conditional use, that seems to make little sense. In your ordinances, there's one other possibility of where you look for the standards, and that would be under 2-71. And that's in the materials I gave you in the workshop. It's on in the clump, although it won't count down that far. But on page 5 of 14 of the handout I gave you, and that's the one of your ordinances, not of the statutes. Under conditional uses, it does have a little bit more short and subjective. The Planning and Zoning Board of Justice finds that in the particular case in question, the use for which the conditional use permit is sought will not adversely affect the health or safety of persons residing or working in the neighborhood of the proposed use. It will not be detrimental to the public welfare or injurious to the property or public improvements in the neighborhood. You are left with the decision, and I can't make a decision for you. I only point out the argument you received so far from Mr. Allen, that those conditions that are listed, that's on your checklist, do not apply because the lead-in phrase. At the same time, a conditional use doesn't exist in a vacuum. And the only other place you've got to look for standards is the one I just read off out of section 2. And Mr. Allen is asking you to make that decision now so he knows what direction he's got to make his case. Do that. Does the list on your checklist still apply? If it does, if you looked at it, you'll have to find, probably going to have to find some of those don't apply anyway. The second is that the shorter one in chapter 2 apply. Third is the decision that the only condition is whether or not the fire marshal says that they can provide adequate fire protection to a taller building. And obviously, the more minimal those conditions get, the less it's like a conditional use. I can't tell you which choice to make, but I can tell you it's your choice. It's your decision to make at this point. And I have given you all that I know to give you in the options. The full list that Mr. Allen argues doesn't apply because of the lead-in sentence. The full list, but with using your judgment to eliminate some of them as being, whether or not they're applicable. The third, use the short list in chapter 2. The fourth decision that if the fire marshal's the only thing you've got to find. Your ordinances aren't particularly clear, and the burden falls on you to make the decision, but those appear to be the options that this board of decisions you got going forward. Full list, probably gonna have to find some of those don't apply anyway. Short list, very subjective. Third list is practically nothing, and just whatever the fire marshal says. But that is about all I can tell you. I can't advise you on which one. You just have to listen to what the attorneys have to say. Look at the ordinances in front of you. Read it for yourself based on what they're arguing, and see if you read it their way or you don't, and then move forward from there. I don't know if that was helpful, but that's about all the guidance I can give.
Okay. Once I get my law degree, I'm sure it would be helpful.
If I might briefly, Mr. Chairman, just to add on what Mr. Sneed said, or I'll wait if you have questions and wanted to say something. I didn't interrupt you.
So would this have to be a board vote as to which one of those three criteria we can go by?
This is going to be a decision that may find itself in Superior Court down the road. And I think it is a board vote, not just a ruling by the chair, on which set of conditions apply. And if it's a long list, then a closer read on which ones can't possibly apply that you just pull out of the list.
And that would be my decision,
It'd be a board decision.
a board decision. Okay. So, as I read our ordinance, I don't believe each of the items on our criteria are what we need to go by, because we've only addressed several of those issues that concern the folks that live in the neighborhood, their concerns and what their witnesses are about to testify to and about. We've heard them and they have a standing right. We've ruled on that. And because of our ordinance that you just read to us, it does look like some of these items, like health and safety of persons residing and working in the neighborhood, proposed use will not be detrimental to the public welfare and injury to public property and improvements to the neighborhood. I do think that ordinance does play in this decision.
Well, I agree. I think that has to apply no matter what.
Right.
That would be in conjunction with the bigger list, if you
Right.
found the bigger list.
Right.
applicable.
And I don't think we've heard anything to value, value being concerned or any of the property
No.
values.
At this point, all the evidence you heard from the witnesses earlier was just to prove that they have standing.
Right,
It was not necessarily directed to the issue at hand today,
right.
although you've got that information in the record and should it play in, great.
Yeah, and that'll be in the
It
future.
wasn't intended to.
Yeah, that is to come, but where we are at this point is to make a decision as to, do we proceed or what to do at this point. They have witnesses that both of them want to call, I'm sure. And I think Mr. Allen would be able to assemble witnesses concerning stormwater and any of the issues that Mr. Noor has brought up. Mr. Allen would be able to go ahead and provide witnesses other than John saying that he walked the property, but then he might be able to dispute Mr. Noor's witnesses, and Mr. Noor would have an ability to ask Mr. Allen's witnesses those questions. And I think that would be best for us to be able to get that information if we're going to make a decision. This is just one item on what I'm sure is going to be conditional use for the rest of the project.
The applicant's position is that this will be the only conditional use request you get concerning this project. He said they're asserting, or he stated, that they want to develop a multifamily development, which is a permitted use. Now, they've got a lot of hoops to jump through, but he doesn't think any more of them are conditional uses. There are some huge hurdles for them to jump through, but they're saying they're not conditional uses.
That's correct. And sorry to interrupt, but that's correct. And when you look at those 7 conditions in 54-255, if you just insert in where it says conditional use, insert in buildings that exceed 35 feet, I think you see how silly the conditions and trying to apply them are. I mean, that's all that this is. And for any evidence that comes in tonight, anything that we're looking at, the only thing that matters is whether it supports or does not support exceeding 35 feet. This isn't a referendum on this development. This isn't a referendum on the zoning. This isn't, do we want apartments or not apartments? The only thing that's being decided is whether or not these apartments are going to be 3 stories or 5 stories. It's going to be the same units. It's going to be the same access, ingress, egress. The 5-story buildings will produce less stormwater, and that's about the only difference. And we're getting way off topic, but there is an adequate provision, an adequate remedy that's in 54-241, and it's very specific in terms of it being related to 35 feet. That 35 feet requirement is there, and it says, hey, let's look at our fire chief. He's the person we pay to look at these decisions. And if he says it's okay, then you can exceed 35 feet. That's going to be the only standard that applies to the 35 feet. That's the only one that makes any sense. And it makes sense. And when we get into the weeds on trying to apply 7 conditions in 54-255, and whether or not, because it's 35 feet, somehow that's going to change utilities or access roads or other necessary facilities, that doesn't make any sense. It just doesn't make any sense. And so that's why it does not apply.
If I may, Mr. Chairman, I think you said it well when again, if all that the code wanted you to do was get a letter from the fire chief, that's all the code would say. Instead, it says you have to go through conditional use permit review, and in a different section, it says we need to know from the fire chief whether there's an issue here with this height based on capabilities of the fire department. These are not, they don't replace one another, they complement one another. And so, as you said, some of these conditions make sense that we need to look at those. And I think the one you noted with public health is one of those. Number 5, related to access roads and drainage and other necessary facilities that are stormwater related, which are the issues we've raised. We've not raised the whole kitchen sink. We've been very specific. And then in number 6, where it says adequate measures have been taken to address traffic congestion. The 35 feet triggers this review. Now they have to present the evidence that shows that they've met those standards that are part of the conditional use permit process, which this board does all the time. So I'm not quite clear on why they're asking to be different than every other person who's come for a conditional use permit. I think it makes sense for the board to proceed with requiring the production of evidence in those areas that apply, and they'll also need to have the letter from the fire chief.
By the same token, if it meant to say that the exceeding 35 feet was part of the same review, the first sentence of 54-255 would say the following conditions will apply to all uses listed as conditional in the permitted use table and exceeding 35 feet. And it doesn't say that. It doesn't say that anywhere, and it doesn't make any sense. And traffic is not going to change because the height of the building changes. Stormwater is not going to change in any positive way in terms of increased stormwater because there's going to be higher buildings with smaller footprints. Those things simply do not apply.
Well, and again, as the chair highlighted, you kind of foreshadowed like, well, we'd expect to see this come back. Well, Mr. Allen just confirmed that he thinks this is the only approval he needs. So that's all the more reason why this would be part of that review process.
No, that's not what I said.
Just, if I may finish, I know I let Derek complete his argument and not interrupting him, and I know we get heated, and I do too. But I think the most reasonable interpretation, as Mr. Sneed laid out for you, is to say, hey, you've got this requirement that says go through the conditional use permit. Is that language right there perfect? No, but you have to read these things together. What were they trying to achieve? And so they say, you have to go through the conditional use permit process. There's explicit standards under that. And it also says you need a letter from the fire chief. I think that's the most reasonable reading of your ordinance. And I think it's consistent with how you have applied conditional use permit standards to other applications that have been before the board. And that would be the way we'd ask the board to proceed.
That's not what I've said. I haven't said that's the only permits that we need. What I've said is the only conditional use permit that's needed is to exceed 35 feet, period. There is a very, very extensive master sketch plan requirement process that's set out in your Mountain Village ordinance. And it covers all of these items related to utilities and stormwater and building location and connectivity of the buildings. So there is a lot of review that's left to go forward. It's just not a conditional use. These are uses as of right. And so once we have that determined on how tall these buildings are going to be, then we turn loose the engineers and send them lots of money and let them draw plans to figure these things out. To try to apply it now just simply makes no sense. And that's why, as we try to do that, it's going to be very awkward trying to apply 54-255 conditions to whether or not 35 feet being exceeded is going to change the architectural appeal of surrounding buildings.
I understand, Mr. Allen and Mr. Noor, but we have an ordinance that's specific to conditional uses, and it does include items, maybe not all of the items in our conditional use worksheet, but it does have items in our ordinance under conditional use that we're supposed to review when we're making a decision on conditional use. That's just the way I read it. I'm willing to put it before the board as to what direction they want to take, just to try to figure out where we're going to go from here. So the motion, what I'm going to ask for is a motion that we don't necessarily have to adhere to all the conditional use criteria that are on our form, but have been specified in some of those issues specific to the height and stormwater that Mr. Noor's witnesses or their folks were speaking to. You can rebut that later on, but I don't think we have to have the totality of all of those items based on the fact that our ordinance reads something separate or another go-by, another direction to go if we're in this position. That's just the way I see it, but it'll be the board's decision as to which way we go. So I guess what I'm going to do is ask the board for a motion as to not adhering to all the items on the criteria that are part of the conditional use worksheet that we have. There's items, we haven't heard anything about property value or any of some of the other aesthetics or any of that stuff, but there are some issues that Mr. Noor brought up that may be in question that we can work out later on to give us a better perspective of which way we're going to go with this. And I just asked the board to go ahead and not use all the criteria on our worksheet, but those criteria that would apply to our ordinance here that may be considered would be what we go by for further on this hearing. Now it's up to the board they're all independent thinkers, and we could either go with it or not, but I'm willing to put it to the board. Any modifications, Mr. Sneed, or anything that you would want to see?
Probably a good time for some discussion amongst the board. I don't know if I'm not allowed to direct you to an answer. I've given you the options that I see in your ordinance. And you got, like you said, you got 6 folks here, probably with 6 different ideas of what they need to know and what this ordinance, for which section of the ordinance is what they should follow to determine whether or not the height limitation should be changed.
So if we can do that, that'd be even better. I mean, I don't want to form something and then have them make a decision based on something that they didn't want to see. So if we want to be able, if we can figure a way during our public meeting to have the board talk about that, I'd be more than happy to do that.
Well, that's when you have to do it, be it this public meeting now or another day.
Okay.
Unfortunately, quasi judicial meetings, they're open and everything's open right down to your consideration, determination, discussion, arguments among yourself on points of order. So if I don't know if it'll be helpful this time, but if anybody else on the board has a thought as to what direction.
Sure, that'd be great. I hate to do this all by myself and come up with this, a conclusion here that which way we're going to go forward. So I'm all up for that. You just tell me how to do it and we'll do it.
Ask anybody what they think. You got 6 board
I
members.
have a comment. I would like to hear from the fire chief
Yeah,
before we go any further.
yeah, I was going to go that way.
And I mean, and then.
Yeah.
I think if talking amongst the board, if they're asking for a conditional use for the 5 buildings and the height, then that's what we have to start with. And then go on with other issues as they come up.
That's the only issue you have.
That is the only issue we have. Now, I would like to hear from the fire chief that should there be a fire, they have a ladder that'll get up that high.
She has a good point, because all the other things we're
It's just
discussing are other
null and
conditions.
void if we don't have a letter that'll get that high up.
Yep,
Right.
I think that's the correct interpretation. That is a has to be, that the fire marshal says.
Yeah, we were trying to get there.
Everything,
I
everything
was-
else is more subjective.
I was to the point saying if we need to get the fire chief's, his information in anywhere before this, but we seem to have gotten to a stopping point before the chief got to go ahead and give us that information. I was thinking we were going to go back, keep continuing until we got to the fire chief.
Well, you would, but I think Ms. Stover has a point that if the fire chief stands up at a moment, is sworn in and says, I can't do it, we can't protect that property.
No, I understand that.
Discussions at end. That's the only rock solid requirement in all of this process.
No, I understand. And that we were going to go there, but we just seemed to hit another stopping point where we have to make a decision.
Well, and this has been the request of just so that we don't. And we obviously have a difference of opinion between the two lawyers are here to prove two different things.
Right.
Mr. Allen's position is that what he's got approved to get a conditional use is practically minimal compared to Mr. Noor's interpretation that we use the long list and they've got to prove every one of those points. And Mr. Allen's asking for a ruling from you now, which route do we take? Do I have to gather my witnesses to prove all of those points on the long list? Or all of the certain points on the long list with some eliminated? Or a different set of requirements altogether, which is in chapter 2, as I read to you.
And just to clarify my client's position, I think we're in that category of there's things in there that apply that we've made arguments about. We're obviously not asking the board to consider things that would not make sense within the context. We think that middle ground is the right way to go. That's why we were prepared to proceed.
And likewise, to recast what our position is not that there are minimum requirements, but there is a minimum ask. This is not a conditional use that's being asked. It's a conditional use process that's being applied to a height deviation. Should it belong here? I don't know, but the fact that it is, we have to deal with it. And there's a standard and there's a fire chief determination from it. We've actually submitted that letter. And since it's been asked for, if Adrian, if you can pull up our materials or I can share my screen, either way is fine. But we do have the fire chief determination that is required and what we believe is the requirement for this to be approved. And that already exists and it's clear under the ordinance.
I'm sorry, I didn't mean to interrupt you, Derek. I guess I would point out is the fire chief here for purposes of cross-examination? I know Mr. Allen was asking that question about one of my witnesses, and so I think we would want that same courtesy and right for due process purposes this evening.
He is here, John.
I don't know if the fire chief is here or not, but the ordinance says it needs written permission. So if you want to challenge the veracity of the fire chief's letter on fire chief's letterhead from the town of Woodfin, I suppose that's a different issue. But the requirement under the ordinance is that we have the fire chief sign off on the safety components of it. And it's very clearly signed off by the fire chief.
Well, I guess that would be part of the point too, is that, just for basic due process purposes, we need to know, is that his letter, is that his signature, the same way that I went through that to ensure that that is accurate information. We're not assuming anything. And then I do think we're entitled to cross-examine in this context. I'm not trying to be difficult. I think we just need to make sure we do this right, because as Mr. Sneed said, this may end up getting appealed by either side. So
Can you hear me, John?
I'm sorry, I'm having a real hard time, Ron. I apologize. I didn't mean to interrupt you.
I'm trying to tell you the fire chief's here.
Okay, great.
So anybody else have any input? You want to hear from the fire chief?
Adrian, have you been able to share that letter?
It would be easier if you had direct access to it, but if you need me to pull it up, I can.
I can pull it up.
Sorry about that.
No worries.
I think the board, although that's going to be a critical part, I think the board is at a juncture here that's been asked to perhaps refine what they need to prove. And one way would be, since the starting point of your packet And the starting point for Mr. Noor is, you got the long list. Would the board like to take a few minutes, pull that list out and go down and determine which ones make sense to apply to this particular conditional use? Will that work? Will that help?
Mike?
So related to that, I would recommend the first three items would be what
I apologize. I can't quite hear you speaking.
I didn't understand what he said.
He suggested that the first three items are what apply.
On the
First
conditional
three
use.
items on which, on what?
On the conditional
Checklist.
use.
Checklist.
The checklist, okay.
And I'm happy to offer the list that we think applies for the board's consideration at the appropriate time.
I'll show you. This worksheet that we're working on.
Permit worksheet.
Mhm.
Got that out.
So which ones, Mr. Noor, do you think would be applicable on ours?
Yes, sir. I think the ones that would be applicable in our view is number 2, number 5, and number 6 are the most obvious there. And I think 1 from the public health standpoint because of the interrelationship between stormwater, water quality, and public health. So it'd be 1, 2, 5, and 6. Those would be the ones that could conceivably apply.
What does the board think about that?
Well, I personally think number 5, we've not heard. We don't have a traffic report. We've not seen it in writing.
Right.
So we don't have that.
Before you look at what, because they aren't through with their evidence, you can't, look at those conditions as
This one?
how those would bear on how tall the buildings are.
Got the article.
None of these apply to what we're
Ten.
discussing and what they brought up tonight, right?
Sir?
None of what they're asking for tonight, none of these kind of go along with that, except for maybe a few of them.
So there'll be and if you'll look at 1 and 2 and 3 as were recommended, those look very much like the provision requirements in chapter 2. It was a very limited list.
Oh, okay.
And that's, again, you might want to hear from Mr. Noor on why he thinks some of those apply. But I think they have to bear on the request in front of you, not on the project as a whole, which those are questions that we raise as full plans come in. But some of these may bear, you need to look at it based on the request that's before you, and that's for a height change or allowance. And would any of these, having that information, make any difference in that decision on deciding whether the building should be taller or shorter?
So, Mr. Noor, the specific ones that you were talking about, if you can address those, Mr. Allen, if you could rebut which ones you think do not pertain. I think I know which ones you're saying, all of them, but just to give us some direction or just some kind of where to go.
Yeah, I mean, for number 5 and 6, I mean, in particular, those are the ones that we've hit on related to utilities, access roads, and other necessary facilities. Now, I know that statements have been, well, how does that relate to height? Well, the height of the building, and I think the height of the building could relate to the density. I know Mr. Allen has said, well, we're going to put in as many as we want, whether it's 3 stories or 5 stories, but well, that's their choice, but the height of it would impact the available density to do that. Whether they choose to meet up at 1394 or not is their choice, but height would play a role in that. The other thing I'd point out is the drainage and facilities that might be necessary to control stormwater off of a taller building. I don't believe, with all due respect, Mr. Allen, I don't believe he's a stormwater expert. So he is an expert in many things, but that would not be one of them. And so again, I think that is related. The height and density of the buildings that are coming together relate to that function, as does traffic congestion. And the traffic congestion with this is, again, I think it's kind of a bit of a false premise in saying, well, we're going to build as many of these as we want to, and so that you're going to have the same congestion no matter what. Well, the standard says you have to go through the conditional use permit process, and traffic is explicitly listed as one of those criteria. And the inclusion of the bridge is an important element in ensuring that the mitigation strategies that would deal with traffic are incorporated into this project. I mean, there may be some misconception from Mr. Allen and his team about whether we're trying to defeat this or trying to ensure that appropriate mitigation strategies are incorporated into the plans. And that's exactly what the bridge testimony will be, is saying that as long as you have this bridge, then you've dealt with the mitigation. But if you don't build it, that would create a huge problem for those who use Richmond Hill Road. And so I think those are the two focal points. I included 1, 2, and 3 in there because I think they're related to those underlying issues. Public health is related to stormwater and sedimentation loading. There's a connection between those that Mr. Carson can testify to. And then number 2, enjoyment of property in the immediate vicinity would relate to height, as Mr. Wilcox said, in the height of the buildings related to his abutting ownership of them. So I think they all apply. And again, we're going to be tailored and targeted. That's what we've been from the beginning, is to say this is related to stormwater and traffic for us.
Mr. Allen.
Thanks, Mr. Chair. Your attorney, the attorney to the board, had it right. These conditions, or any conditions that are going to be used, if they don't relate to a change in height, then they're not applicable. Here, if you look at each one of these and ask yourself, does it matter if it's taller than 35 feet or not for consideration of this condition or this element? I think it becomes clear, and it is, even for the first 3, it's extraordinarily cumbersome to try to distinguish how the height is going to change that. The height is not going to change the density. It's not. They're 82 acres, and the density is 17 units an acre, and height will not change the density. Height will only make the footprint of this project bigger. And it still baffles me that the opposition here appears to be asking for a bigger footprint, because that's the only thing I keep hearing. Similar to height, traffic is not going to be dependent on height. Traffic and density are going to be what they are, and they're going to be dependent on the number of units and the number of units and the number of occupants in those units. And those numbers, density, numbers of units, and the numbers of occupants in those units will not change. So traffic and is just not going to, I don't see where that comes up. Same with utilities and access roads, all of these things, the architectural, I don't think that one's in consideration, but all of these, and maybe that's why it says it in the first sentence, that these conditions apply to all uses listed on the condition on the permitted use table, and height is not listed there. So I still don't see from the plain language, the plain English that's here, how these conditions apply. And I think that you have a condition that's already set out that's specific to height related to the fire chief, and that one in 54-241, that tells us what we need to be doing.
Briefly, I mean, and then there's the other provision that says it has to go through conditional process review, and that these are the applicable standards. I mean, I think it is clear that these standards apply.
Well, the ambiguity in North Carolina.
And Derek, if I could just finish, I won't interrupt you.
The ambiguity gets resolved in the in favor of the use, John. Well, you want to have a rebuttal every time I say something, and I'm letting you do that. Here, if there's ambiguity in the ordinance, it's resolved in favor of the use.
I don't agree with that statement and that there's ambiguity.
Black letter law.
Well, again, the next point that was made was that somehow it was throwing on my clients to suggest that we were asking for broader use, lower stories and a smaller number of stories and broader development. That's simply not true. Well, the developer could make the decision to have the same number of buildings with less units at a lower height. That's not a decision we make. And so insinuating that somehow we're asking for a worse development by engaging in this process is just not an accurate reflection of our position. We're asking that they present the evidence that meets the standards for the conditional use permit.
Okay, I think most of the board wants to hear from the chief. So why don't we hear from the chief since he's been here all night? We'll hear from the chief and then maybe we'll give this some consideration before we make our decision. But at least let us hear from the chief and see if he's met the goal. Mr. Allen has met the goal for what his request is. We will at least have heard that part of it, and we will make a decision based on all the witnesses that we've heard tonight.
If I could reserve my cross-examination for Mr. Holdsworth, I wasn't able to complete that, but I'm happy to move on to the chief if that's where the board wants to go now.
Okay, could we hear from the chief then, Mr. Norton, if you want to go back on John and make some?
Yeah, I'm happy to do that at a separate time to move on to the chief if that's where the board would like to go.
Okay. So Mr. Allen, would you like to call the chief?
Yes, please.
If you state your name and your position, sir.
My name is Chief Dennis Fagnan, West Buncombe Fire Department Fire Chief.
It's all yours, Mr. Allen.
Thanks very much. Thanks for joining us. Chief, this evening, I have up on the screen a document that appears to be signed by you. Is that in fact your signature?
That is my signature.
Is this a letter that you signed, including the attachments?
That is correct.
And was this letter in sum and substance reviewing height for safety under your ordinance?
I was reviewing the height safety as provided by the town of Woodfin's ordinance. I do not fall under, though, through contract with the town of Woodfin. I do provide fire coverage for the parcel in question.
Excellent. And specifically, this letter appears to be reciting the requirements in 54-241 of the town of Woodfin Code.
That is correct.
And do you have any concerns with this project and the buildings exceeding 35 feet from a fire safety standpoint or any other standpoint under 54-241?
I do not.
We would move to introduce this letter into evidence as compliance with section 54-241 of the town of Woodfin Code. I have no further questions.
We don't object to it being entered into evidence, but for the, as established by the witness. I have a couple questions for the chief. Derek, do you mind taking that down for a second, please? Thanks. Okay. Chief, I think I put up the same statute here, 45-241, and it says, correct me if I read this wrong, but heights of buildings shall not exceed 35 feet unless written permission is first secured from the appropriate district or town fire chief in order to determine, and then it has two conclusions underneath that are for your determination. If the height of the structure exceeds the firefighting capability of the fire department, and two, to determine if the structure meets fire safety standards, including fire escapes, et cetera. Did I read that correctly? Just so everybody's working off the same page.
You did, Mr. Nolan.
Okay. And related to that determination, I know that one of the council, or excuse me, one of the board members had asked if your current fire trucks had the capability of servicing a building that would be of this height at the upper levels. I don't want to mischaracterize the question, but it's one of the questions that I heard. Is that currently within the capability of the crews that would service this property?
That is within my current capability.
What is the largest building that you currently serve at present?
Stories by building, but we exceed 6 or 7 due to elevation in the mountains.
And when you say 6 or 7, I'm sorry, was that?
Well, I have to take into account the elevation of a building in relation to the terrain. So a building that would normally be 3, maybe even sometimes 2 stories is going to end up being 3, 4, or 5 stories high. And again, as I stated, some of them I have to consider 7 stories. So while I have a 105-foot ladder, even a residential 2-story, depending on the terrain, may be outside the reach of my aerial ladder.
And
Hey,
so,
hey, John, sorry to interrupt you. I'm looking at my notes here and I'm not sure that we swore in the chief. I think we need to swear in his testimony, and we can go back and do
I can
it.
just ask him if he, affirms everything he previously testified to, if that works for you.
That's what I was going to suggest, just to save us some time. Thank you.
Yeah, that works. I think the chair might need to swear in.
You solemnly swear that the testimony you're going to give tonight is true to the best of your knowledge?
I do.
Okay, and Chief, do you swear that the testimony you previously gave in response to the questions asked by Mr. Allen was true and accurate to the best of your knowledge?
I do.
Okay, and the questions I asked you up till now as well?
I do.
Okay, so yeah, in where we were is, I think, talking about the length of the ladder and how even 2- and 3-story buildings can actually amount to higher, the effective height of much larger buildings. So in a situation like this where you have 5 stories, could that effective height be in the range of 7 or 8 or in excess of that many stories?
Yeah, it's very possible that could happen.
Okay, and I think your testimony, I don't want to mischaracterize it, was that your current ladder, was it you either could or could not reach that for those kind of levels?
So when you get above 7 stories, it becomes difficult to reach those types of stories. In my decision-making process, however, when it comes to those type of structures, which I did consider as part of this project because of the possibility, is due to the assertion that these buildings will be met to NFPA 13 and NFPA 14 requirements. So that's going to be the inclusion of a fire suppression sprinkler system and a fire standpipe system. In the event that my ladder does not reach those upper floors, I will be able to utilize those standpipe systems to extend hose to the area of origin.
And so if I'm hearing you correctly, you're saying that your ladder does not, you don't have ladder capability for those kind of heights. If they exceed that 7 stories, that would be difficult. However, there are other standards you've been assured will be incorporated that lead you to believe that you can meet the needs of the building. Would that be a fair summary?
If the building stories exceed that 7-story magical limit of my ladder, yes, as provided the buildings are constructed in accordance with NFPA 13 and 14.
Okay. And I wanted to just pull up here, what documentation, I mean, I know in your letter, and I've thrown up on the screen here, you said Mr. Holdsworth has provided assurances. What documentation and evidence of the building design has been provided to demonstrate compliance with that at this point for your determination, not at some subsequent determination?
Absolutely. That's going to be in accordance with the North Carolina Fire Code.
So, but has any documentation been provided as of today for your determination?
Other than using the height he has described as aligned to the North Carolina Fire Code, that would be required as part of the permit review process.
But no documentation has been provided as of today on that, just his assurances, correct?
I understand the question you're asking. I don't want to beat around the bush about it. So in order for him to build the buildings as he has laid out, they would have to meet those requirements. To answer your question specifically, that is correct. Only his assurances were provided.
Okay. Give me 1 second. Just a brief question. You mentioned in here that Mayor Vihan had spoken with you about this as well. Can you tell me the substance of that conversation?
Yes, initially Mayor Vihan was an intermediary between Mr. Hollingsworth and myself to introduce me to the project and make sure I was aware of the particulars that had happened. I only became fire chief. This is just now a year and 1 month.
And so he was assisting Mr. Holdsworth with making connections with you. Is that correct?
That is correct.
Okay. I might just have a brief moment, Mr. Chair, just to look through whether I have any other questions.
Sure.
I did just want to circle back on one question I'd asked is, are there other, with this predicted height on I think that you have in your letter, I had asked whether you had what the largest building in your current capability service area was, and I just want to make sure I'd gotten an answer to that. Do you have anything as tall as this is projected to be, considering the topography within your current capabilities and service area?
I do not have any 5-story constructed buildings within my district, but I do have 5-story heights, if that makes sense.
What about the 7 stories and 8 that you thought were plausible from this?
Yes, that also exists. Not in story construction, but in height is taking in topography.
You do have those currently or do not?
No, I do, absolutely.
Okay. I think those are my questions for the fire chief.
A couple of follow-up questions, if I might. And I don't think that Mr. Knorr had the same version, or at least didn't have the exhibits.
I only had what Ms. Eisenhower provided me this afternoon when I received it around 4:30.
Sure.
I don't have any exhibits.
There are a number of exhibits, including the height, building height. Were these 3 exhibits part of the letter that you reviewed and signed?
Yes, Mr. Allen.
Can I be provided with a copy of that since I haven't seen those yet?
Sure. And in addition to the letter being admitted, we want to make it clear that we would accept and offer up the conditions to development, specifically the fire suppression systems and all the requirements and assumptions contained in the chief's letter as conditions to granting of the ability to exceed 35 feet in height. So we accept these as conditions to the development and would tender that to the board for approval as appropriate conditions.
If I could just receive that copy of the documents I haven't seen, so that if I have any questions for cross-examination based on those, I just need to see those first.
They're in your inbox.
Thank you. Just have a couple of questions for the chief as follow-up now that I've seen the exhibits here. Chief, as attached is, and I'm just going to throw these up here. Attached as exhibits are the 2 documents that I think Mr. Holdsworth is now, he testified, are no longer accurate related to the project related to the number of units. And I see here on the last page, there's a schematic that kind of shows a profile with height. Is the height the only relevant factor in your evaluation of this kind of project?
Yeah, thank you for that. No, not necessarily at all. So there's a number of different factors that went into my decision to my letter. And so, yes, height is one. I also have to establish what the setbacks might be. In addition to, of course, the sprinkler systems, my manpower, and my travel distance to an area. So as you go up in density, as we see with here, so you have 5 stories, I have to be able to put a number of firefighters on scene to be able to hopefully mitigate this fire while it's still small. So those are a number of different factors that were factored in. So it wasn't just the fact of building height, and it wasn't just the fact that it was an NFPA 13 and 14 building, but also my manpower and my travel distance to this location.
So the number of units would have an impact on your assessment, and that, you know, considering the breadth of a fire that might take place, whether you have sufficient resources to service that structure system or multifamily project?
Right. That's when you're looking at a multifamily project, you never just consider one individual affected. You're going to look at maybe an entire building, maybe an entire floor, or maybe an entire wing. So I never look at it in just a single occupancy, although that's our hope, of course. I don't want to rely on that fact.
Well, I don't want to be, it may seem obvious in some ways, but you evaluated a proposal that had 1,545 units, correct?
Just to be very candid with you, I can't say I put that into my equation. The original packet that I reviewed and initially had received from Mayor Vihan explaining this, that was relayed. And so it was the number of the buildings that I was looking at and just estimating. So you look at manpower in terms of immediate rescue, firefighting capabilities, and again, like I said, travel time.
Okay. I think those are my questions based on that. Thank you.
You're welcome.
Mr. Allen, do you need to clarify any of that?
I do not.
Any more questions for the chief?
I do not have any more for the chief. Thank you.
Thank you. Okay, Mr. Allen, do you have other people that you would want to talk?
I do. Mr. Nord, did you need to go back to Mr. Holsworth?
Hold on a second. Mr. Mahler? Oh, sorry, one of the board members has a question for the chief.
So did you have a chance to look at the impact to the utility systems that are available currently? If a fire were to erupt in any one of the structures, is there sufficient utilities in water and power to provide the 13, 14 schools of fire?
So there was an evaluation I initially, or what I would say cursory made. This will all get flushed out in the permits review process. So I do look at the availability of water. So part of that Asheville water is over in that area. They do have a very robust system. There's talks about Woodfin extending their water over there. So again, the idea that I did look at water, yes, water is there, and I'm satisfied with that. There is no reason for me to look into utilities beyond water. That's going to be my primary resource that I'm interested in. So I can't speak that I looked at any other utility.
Any other questions for the chief?
I guess just one follow-up, sorry, based on the question that was just asked.
Not so fast, chief.
I need to get steps in anyway.
Yeah.
I will be brief. So you had indicated that, I think that there has been some information out there that utilities might be run across the proposed bridge to the development site. If the bridge was not constructed, are you satisfied that the utilities that currently on the property, not potentially available, but currently on the property, could service the water needs for this kind of development?
Let me be specific in my answer here. For fire suppression, yes. I cannot speak to any kind of domestic water use, but I am satisfied for fire suppression.
Okay, well, I guess maybe one or two follow-ups on that. So this is a multifamily use apartment. Obviously, people are going to be living there and using water domestically. If your answer was, if I want to make sure I understand, your answer was, I think there'd be sufficient water without the bridge for the fire suppression. Well, what about, I mean, the buildings won't exist unless there's also domestic also being used at the same time. So would that change your understanding?
In the event of a fire, I'm not concerned about how much water I'm going to use. I'll use 100% of the water available to me, which may mean some buildings don't have drinking water for that period of time. But as a fire service perspective, that's of no concern to me in that period of emergency.
And that's based on available utilities on the property as of today.
In that area. So yes, Asheville Water is in the area.
Do you know whether it's on property already or not? Would it have to be extended?
I do not know the answer to that, sir.
So there's nothing on it currently. It would have to be extended from the city of Asheville under your assumptions.
That is correct.
Okay, those are my questions.
Anything further, Mr. Allen? Mr. Allen?
Yeah, one last question. From a fire station, yes. From a fire station standpoint, Chief, would you rather have 7 5-story buildings or 7 3-story buildings with larger footprints? Oh, I think we are.
I did hear you. I'm sorry. I'm going to just need a moment to weigh all those variables. That's a big ask.
Sure.
It's a big ask. A 3-story, a fire in the top floor apartment is going to give me access to a roof a lot easier. 5-story, given your proposal and topography, may or may not be able to make the roof, therefore relying on the fire suppression system, sprinkler systems working, and standpipes. So in the end, off the cuff, I'm gonna have a break-even point on which. So I guess I'm gonna tell you, I don't have a preference. What I am concerned about with the 3-story is you had already mentioned in that there's going to be more surface parking. That becomes cumbersome for me to make access to a building versus a limited amount of surface parking, giving me more direct access to the building to make full advantage of my reach of the ladder.
Fair enough. I have no further questions.
I have none either. Thank you.
You can go now, Chief. And I'd have a pager go off real quick saying you had an emergency. But you can go. You don't have to stay any longer, sir. Oh, you want to stay? You want to be a board member? Okay. So so now we're back to John. Am I right, Mr. Noor? You had some questions of Mr.
I did, but I did want to fly by the boards, and Mr. Snead suggesting that at this point, does the board want to make a decision on what additional information they think is needed under the standards, so we're aware of that, because I think that then dictates whether that's Mr. Holdsworth or any of the other evidence that needs to be presented going forward. We're also at the 10 o'clock hour, and so not knowing the board's preferences, maybe this, depending on what your decision would be, would create a natural breaking point for the evening.
Well, we thought we would go to about 10 and then figure out what we were going to do. And everybody had just gotten a lot of these materials this evening. I mean, we haven't really had a chance to read every document that we have. And we might be able to explore some of the questions, the legality issues about, which conditional use. I believe most of the folks had got their answers to the questions that they wanted. And maybe before we continue on, we would be able to get just a tad bit more advice on our ordinance and how it relates to those conditional uses. And then I think we can make a really good decision. But I think if we give a pause to that and then continue this at a later time, it'll give us a chance to read all the documents, all the materials, and then go further on that. Can we do that, Mr. Sneed? Can you tell us which way is the best way to do it? Since we don't want to close our public forum, we want to, because then we can't ask any more questions or go any further. So you can tell us the best way to do that.
Let me tell you the limitations between now and when you reconvene. Is between now and the time you reconvene, you can't consider this project except what's in front of you study.
Right, talking amongst
You
ourselves.
can't talk amongst yourselves.
Yeah.
And so we might take just a moment so I can repeat the same thing again that's muddying the waters. And if you want to adjourn for the evening, continue to a date certain or your next regular meeting, you can do that. But my concern is for the parties who have to know what evidence to put on when they come back. Does this board want to take a few more minutes now and try to think through what conditions they think and make a determination as to what conditions the applicant has to prove to get his conditional use? We have had one of your members say 1, 2, and 3 of the long list. I think John said, I can't remember which one, but 1 and 5 and 6. I have tossed out the possibility of none of those, and you go to chapter 2 in that short list as conditions. You heard the argument, and or at least the statement that hasn't been presented to you yet, but was made between John and Derek, is that when you have an ambiguity in an ordinance, the decision has to be made in favor of the free and unfettered use of the property, in favor of the property owner. That is one approach. What I think you've been actually looking at it. The other approach is you got to read your ordinance in totality. You got to look to all of it and try to make sense of what the people who drafted intended. And you can look at precise wording, as Mr. Allen has said, to look at that first provision that says these are the conditions they have to meet for every conditional use listed on the permitted use table. If you read that exclusively, then none of those conditions apply. If you take John's approach that it wouldn't be called a conditional use if it didn't have to meet the only set of standards you have, then I think even John and your members picking out separate ones, but some of those just can't be made to apply. And then you've got that chapter 2 that has a very basic statement about those fairly subjective statements as far as providing evidence, what a conditional use has to meet. I hate to put the pressure on you. I know it'd be nice to go home and read these and scratch your head, but I can tell you that when you reconvene, your hearing is going to go a whole lot smoother, one way or another, if the parties leave here tonight knowing when they come back to your reconvene meeting exactly what standards have to be proven or disproven. We've been, like I said, we left off with a recommendation that the first 3 on the big table apply. Mr. Nor's request that 5 and 6 be made to apply. And then whether or not none of those apply and only the provisions of chapter 2 apply. If this board can hash that out and come to a conclusion that makes sense to all of you, at least enough of you that a majority can agree, the parties will come back to the reconvene meeting with a far more organized presentation for you that you can work your way through. Otherwise, they'll all have to come loaded for bear, not knowing what the standard is till they get here.
So where was chapter 2, Mr. Sneed?
Chapter 2, and in the handout I gave you, in the one that numbered funny, but up at the top, upper right, it says page 5 of 14. And a couple lines down, it says C, conditional uses. Then under C, there's a subparagraph 1 and a subparagraph C. That subparagraph C says the Planning and Zoning Board of Adjustments finds that in the particular case in question, the use for which the conditional use permit is sought will not adversely affect the health or safety of persons residing or working in the neighborhood of the proposed use, will not be detrimental to the public welfare or injurious to the property or public improvements in the neighborhood. And I think that is your overreaching set. Even if you go with some of the items on the long list, I think you've got to make those findings. Now, those findings are blended into your other 8 findings already. But I think you've got those to meet no matter what. You may have additional findings from the long list that you feel are applicable.
We talk amongst ourselves. I'm willing to stay here as long as we need to. You know, so I mean,
I'm not willing to stay.
I'm not at all.
I'm not either.
4 o'clock was a long time ago.
I know, I'm a nurse. I gotta go to work again tomorrow.
Let me find it for you.
I don't think it's in here.
Yeah, this is what the chapter
Chapter
2.
50, that's 2,
Yeah,
that's
that's
273. I'm talking about 54. That has it all.
Oh, that's the one we went
Maybe
back
yes.
to. Let me find it for you. It was the one that has the condition.
That's checks. And from what I understand, they have to meet all of this or it doesn't apply.
What we were talking about is some of them, it can meet some of them, we can narrow down how many would be required. There's a discussion of only the first 3 items, and then we're just, Mr. Nora wanted 2 items. Let me find it for you.
But we've only been asked to look to one conditional use, right?
Yeah.
And that's the height of the building.
Right. There you go.
Not, we haven't seen plans, we
These are the-
haven't seen any
Right,
roads.
right.
We haven't seen
Right.
any traffic study. The only
Again-
thing we've been asked to do is to look at, can the building
Right.
be extended 35 feet?
And the arguments are that it could meet some other conditional requirement, not all of those requirements. Or we can go to chapter 2, which is an ordinance that has to do, did you read that part? The ordinance of what we, as another basis for the conditional use?
Or use an
Or the
ordinance.
original, that is, if,
Original, right.
if the ladder will go to the top of the
Right,
building where
right.
it's good to go. So those are the 3 choices. I don't know, you know, I'm at an impasse as to what to do.
Well, it really concerns me behind the buildings. It's harder for them to put out the fires.
Yeah, but it'll have sprinklers and it'll have hoses that you can tap into on each of the floors that the firefighters use to put the fire out. So it doesn't matter if the ladder gets up there, but the firefighters have to go into the building, hook up to the line, and then bring the hoses to where the fire is. So that's code, that's building.
It is a North Carolina code, no?
So. Does anybody have a preference for which direction we go? Be specific, if the ladder gets to the top of the building, we're good to go. There's the ordinance that says that we have to take into consideration the health and safety of persons residing and working in the neighborhood. Proposed use not be detrimental to the public welfare and injurious to the property and public improvements of the neighborhood. That's chapter 2, which is an option.
Mr. Collins suggested doing 1 through 3. Would you like to start that as a motion and continue the conversation based on that?
Yeah, we can do it that way. If Mike, is that your motion that we just look at 1, 2, and 3?
Yeah.
Okay, and how about with Mr. Noor asking 5 and 6? Or Mr. Noor was 1, 2, and 3, and you want to add 5 and 6, or do you want us to do that separate?
I think mine were, I had said 1 and 2, and then 5 and 6. I don't think I included 3. That's the one I asked, but I'm happy for 3 to be included if the board member would like that.
Well, you have a motion on the floor
Yeah,
for 1, 2, and 3.
yeah, so the motion would be Mike's motion for 1, 2, and 3. Somebody want to second the motion? Okay, Mike's motion does not carry. For any modifications, maybe for the conditional use 5 and 6? What was it, Mr. Noor, 1, 5, and 6?
1, 2, 5, and 6 were what we would
5
request.
and 6? Did you want to review that?
Just a quick question for you, Mr. Noor, if I can.
Yes, sir.
In terms of number 6 and our task of whether or not we can go above that 35-foot marker, how does that ingress and egress determine or affect that height?
I think that's part of the heart of the disagreement. I mean, what I have been arguing on behalf of my clients is that 35-foot, exceeding 35 feet triggers this conditional use permit review. And that the board then has to look at the standards that are in that list, 1 through 6, and find that evidence has been presented to the relevant ones, which as we say are 1, 2, 5, and 6. And that's how it should be analyzed. It's not this, you just look at how height could impact traffic or how height could impact stormwater or something like that. Again, if the commissioners who passed this had just wanted the letter from the chief, they would have said, well, just go get a letter from the chief and there's no need to go through the conditional use permit process. It's kind of, these meet together. You have the height that's signed off by the chief. You still have to have the project. And as Mr. Allen said, they won't be bringing this project back. This is the review. This isn't, they believe this is the only approval that they need. And so those factors become relevant in understanding the entire project as a whole, unlike other situations where you might have it come back at different times.
Thank you.
Somebody like to make a motion for Mr. Noor's request that looking at conditional use 1, 2, 5, and 6? Somebody want to make a motion? Okay, that motion does not carry. How about a motion for for what we said was chapter 2? The Planning and Zoning Board of Adjustments finds that in the particular case in question, the use of which the conditional use permit is sought will not adversely affect the health or safety of persons residing or working in the neighborhood of the proposed use and will not be detrimental to the public welfare and injurious to the property, public improvements in the neighborhood. Somebody want to make a motion that that's what we consider? Okay, that motion doesn't carry. That leaves Mr. Allen's condition that it all matters that the police chief has signed off on the structure being approachable by a fire department and it's met the criteria as Mr. Allen has laid it out. Somebody want to make that motion?
I'll make that motion.
Somebody want to second it?
I'll second it.
Okay. So we'll take a vote on that part. We'll do it by order. Mr. Angel?
Yes. Grimmett, yes.
Raza, no.
Lamb, no.
Stoker, yes.
So carried. I'm sorry?
No.
We're at 3 and 3.
Motion fails.
Motion failed.
Yeah.
Still kind of make that a comment?
Sure.
So, let me think about it. So the reason I went for 1, 2, and 3 is I believe that there is an impact to the local surrounding community for buildings that exceed 35 feet. We're talking about adding another 20 feet, which does affect the visual impact of the surrounding community. That affects property values, that will have an effect on how people look at your community as a whole. And that's why I look at 1, 2, and 3. I would want to hear from the developer why he thinks that going to 55 feet rather than 35 feet would have no impact in terms of visual quality. So I'll go back to my proposal about 1, 2, and 3. That's why I chose 1, 2, and 3.
Since everything has failed, we can consider all those motions as at least a discussion amongst the board. So now you've got a feel for what each thinks. And I think it's parliamentary okay to put that motion back on the table.
Mike's motion.
Yes.
Okay, so we'll reconsider Mike's motion to consider 1, 2, and 3 on the conditional use as our requirement. Would somebody second that?
My only comment is if we're gonna say that that's gonna detriment the community welfare, then it's in my belief that all of these will in some way have a bearing on the community welfare of the project in its entirety. So if I feel like if we're gonna throw that one in there, you just need to have all of them in there. Because in some way, they're gonna all affect.
But does height affect those?
I'm sorry.
Does the height affect those? Think of them backwards just a second and then see if you can apply all of them.
But was it mentioned in our worksheet? Was it specifically mentioned in our worksheet to consider the height?
No, but that is the, that is
Number one has
that is the
height.
issue.
Hmm?
That is the issue.
Yeah, I know.
Number one has
I missed
height.
it.
Number one's the only one that mentions height, bulk, scale, or appearance.
Yeah.
Number four has height.
She reads better than I do. Thanks.
I've been at it for a while.
She wrote it, so we ought to know.
That's what's happening over there.
She's our historian, but it does say height in the first consideration.
Well, the thing about it, eventually it's going to affect the whole project.
Right.
So that's why I can't see how you can just isolate one thing.
But we don't have any of the other information, and that was the
Then again,
question.
that once you decide what they have to prove to get their conditional use, they will hopefully then bring you that information.
Right.
Right now, we're leaving, I don't want to walk, I know I'm making you guys stay here and suffer, but it won't serve any purpose not to reach a conclusion on that point tonight. Come back in a week or a month and pick up with this discussion, and the lawyers and the parties having a month not to know what to get ready for. You know, even if it's bad news, a lawyer can figure out a way to deal with it. But they're younger and faster than I am, but I don't know if on the fly at the next meeting, you can tell them what the rules are and start right there and then have the proper witnesses ready. So if we can reach a conclusion tonight that will work for the majority of you, these lawyers are good. They'll find a way to work with it. But if we give them no rules to play by and ask them to come back in a month, we'll have gotten nowhere.
Mr. Sneed, to that end, I know that the standalone fire chief requirement was something that had been ascribed to me as Mr. Allen's proposed standard, but might offer up adding in the Chapter 2 findings and the fire chief letter provision as a compromise to get a little bit of the best of both worlds and combine two of those motions and maybe get a positive vote that way.
Well, I think, and I've directed this board, the fire chief's decision was critical. And I think that's why she wanted to know. She knew if the fire chief got up there and said, no, we can't do it, this hearing would be over. That is a factor. And I think that's why she wanted to hear from him, just to know that was out of the way. But we know that's got to be proven. And the question is, to what degree, what information, what evidence, what findings they have to make for your conditional use. And the board is, as you can tell, struggling with that. I think what Mr. Allen has just proposed is the Chapter 2 plus the findings of the fire chief.
But it specifically says height in number 1. In the
Number four.
like in our worksheet where it says compliance, it specifically says height.
I don't think that worksheet is taken out of the ordinance. I think that is just a worksheet. I don't think there's any statutory or ordinance basis for that. And I'll defer to Adrian and Mr. Sneed for follow-up, just to kind of get us back on track.
I mean, for context, I think the language comes from the ordinance, and then those parens talk about examples that can fall into that. They're not exclusive, but they're examples. And so that's why we've asked for all the ones that we think can fall into those based on the requirements for the conditional use permit as a whole, those 6 standards.
If you look at your ordinance in the handout I gave you earlier, and it's 54-255, I assume, yeah. If you look at the tops of the pages, if I didn't staple the number of it, it says conditional use requirements, 54-255. Those all, that is the exact language of your ordinance. So if you have a question about what your checklist is telling you, those are the 7 you're looking at, the actual language that the checklist was created from.
It does not have height listed in item 1.
Yeah, those are examples that were put into the checklist.
I'm glad we clarified that. So there is a motion pending, and Mr. Mollings is, we've gone back to saying, am I correct, Mr. Sneed, that Mr. Mollings 1, 2, and 3?
Yeah, that's his motion, and
Is that the one on the floor? I
unless
thought
it
we
dies for
just
lack of a second.
voted on.
Yeah, but he's brought it back up.
Oh,
So we'll put that before the board. Mr. Mollings' motion for 1, 2, and 3 for consideration of this project. Will somebody second it? I'll second it. We'll take a vote. Raza seconded it. We'll take a vote from the board. Roll call. Mr. Angel,
Jeff Angel, no.
Jay Grimmett, no.
Ken Razza, yes.
Lamb, no.
Stoker, no.
Okay, that didn't carry either.
All right. Okay, we've got 6 people and 6 opinions.
It comes to me as to what they ask for.
It is, but
And it says conditional must be acquired for buildings to exceed 35 feet in height. And to me, it doesn't matter if they're that way or that way on side of the mountain. It's gonna deter the beauty of the mountain. You know, we all wish we didn't have to put anything on mountains,
well,
but
then,
where we live.
well, the thing is there a standard that they have to meet that's spelled out in your ordinance that addresses that?
Well, chapter 2 is the one that I saw. It was a compromise between all of the 6 items, and then chapter 2 was a broad-based. If it wouldn't be in the ordinance, if that wasn't intent of who wrote the ordinance, to take into consideration after all the conditional use, there was another option in here that was listed as a choice for conditional use.
Well, it's not a true choice. That standard in chapter 2, I think the way it reads, it applies no matter what. But if you apply all the standards in chapter
Well, ask them to pull it up.
54, those requirements are in there.
Adrian, do you have a copy of the ordinance and shows 54?
It was in
Chapter
that
54.
handout I gave you today.
She has.
Yes, but it just mentions 54, and I don't know if that's
Yeah.
anything applies to it or not.
It just says chapter, well, not, yeah.
255, and it'll be highlighted right at the top.
It's a couple of pages back, Adrian.
It's right here on page 10 of 14.
No, right here, it
Next one.
shows. See where it says, well, that's just like our points here, the thing.
for chapter 2?
No, 2 is here. I'm looking for chapter 54.
What in chapter 54 are you looking for?
What it's referring to, right here,
It's 4th page back
the
from the end of
conditional
that
use
packet.
and what's authorized.
Which is this.
And then that's the conditional uses. Okay.
Somebody want to make another motion?
I'll make the motion just to go off of the worksheet, full worksheet.
The full worksheet?
We haven't tried that one yet.
We don't have all the information for it.
Yeah, he hasn't gotten to that yet, but they, when they,
all the information until you get to those standards.
yeah, they come back and then they have witnesses to speak to these other issues. If that's what you want to hear.
Basically, right now, we're trying to determine what their standards are they've got to meet, and they'll come back and then bring their witnesses down and see.
Yeah.
Now, there will be things you haven't heard yet. We were barely getting into it, and we got into the conflict about what they have to prove.
Yeah, they were going to get more specific as we continued on. They would call their expert witnesses to testify on each of the issues. that
And
we know.
that's what I'm saying. The one thing they asked for was 35 feet. I mean, it doesn't fit in any of these.
Well, that's part why you're getting different motions to use just ones that seem to fit.
Look at that.
1, 2, 3, Mr. Noor had, right? 1, 2, 5.
1, 2, 5, and 6.
We had a motion to ignore those and just use chapter 2. We had a motion to ignore both. Let's go with the fire chief. I will tell you that if you look at as a whole, we call it a conditional use. Somewhere, hopefully in the ordinance, there are conditions that they have to prove. And I tell you that chapter 2, I think that if nothing else, they have to prove those. Those are overreaching. Now, if you go with the provisions of the long list, chapter 54, if you read those and look at chapter 2, you'll see those things are in there. They're in spots. So it's a matter of whether you know the fire chief's got to pass. If he'd said no, then we would have been done. That's a requirement separate from the rest of conditional use. The chapter 2 conditions have to be found. So that's all you have to find or not, that's what you're trying to decide. So we looked at the long list in chapter 54. We know that some of those, and here Mr. Norris pointed out, is noted that some of these just cannot be made to apply to a height analysis. So you're down to either chapter 2 in the fire chief or fire chief and select items from chapter 54 of the long list. We had 2 suggestions as to what comes from the long list. And I think at least some of you, at least probably the majority of you, do at least want some detail in the information you're going to get and not just the generalities of chapter 2.
Yeah.
So if you can hammer it out and pick which ones are pertinent to height in the long list, your checklist, perhaps you can agree on what those are, and get a motion that we get at least 4 votes on.
Yeah, I was thinking chapter 2 is fairly open-ended, and it's not as specific as the picking which item it is.
Right.
And it'd be up to the lawyers to actually prove or disprove those items in chapter 2 as to whether or not they were, and then that we can render a decision based on how well they do with their witnesses, their expert witnesses, their cross-examination of each of them to see if either any of these issues could be proven. And then if it actually comes down to, look, the ladder can get to the top of the building, that's an option for us to do.
Well, you've got the fire chief's information, and
Yeah.
until we have, and again, we may have counter evidence to that by the time it's over.
True,
And
true.
So we don't know that. That's not a given yet.
Right, that's why I'm
We're going
saying,
to give it if the fire chief said no.
right.
If he says yes, that's not locked in stone yet.
Well, if he thought he can go home, he would have said no, I think. But no, I was saying that the chapter 2 to me was one of those that we could work with, that's a compromise between going to the specific items on the conditional use. And if that's in our ordinance, somebody who wrote that ordinance thought that this may be an incident that we would have to address, and it wasn't specific, as it says in the conditional use on all those 6 items. And it's not as single as having the ladder go up to the top of the roof, and if there's enough water, it's something for us to work with to go forward so that the attorneys could either prove or disprove what those items are. It gives them a chance to go ahead and talk about the water and the traffic and all that stuff and have their expert witnesses to come up and talk about all those items, whether they relate to what each individual thinker feels was completed, then that's an individual decision. But right now we're at an impasse. We have to go somewhere, and I figured that was a reasonable accommodation.
Are you, is the Richmond Hill area your district?
Yes.
Okay. So if they have a fire, even the average person there, you would reply?
Yes, the Richmond Hill area is my district. We just recently built a substation, and that was considered a part of this, my decision-making as well. I used 1 Minuteman Drive, which is the National Guard Armory, and that is 2.2 miles from my station, the closest state responding unit.
He can call on other assets if he needs them. He can call on.
Absolutely, we have a robust mutual aid system.
Yeah, he can call on Jeff. He can call on the city of Asheville.
The city of Asheville would
And
absolutely.
they got a bigger ladder truck than I think you do. So
Same size,
Same size.
if we're going to compare sizes.
there you go. I'm not a fireman, but I pretended to be one. So does somebody, if I make the motion that we go with chapter 2 and then let the lawyers prove or disprove each other and argue it out amongst themselves for us to go forward, would somebody second that motion?
Jeff Angel will second that.
So if we take a vote, we can do a roll call. Yeah, well, and it's not because we want to go home.
No, we're married.
I mean, we're here forever, but, so if we could take a roll call, Mr. Angel?
Yes.
Okay,
Yes, Grimmett.
Graza, yes.
Al Lamb, yes.
Stoker, yes.
Okay.
I may not
That's
like it,
unanimous.
but I'll go yes.
Okay, so we have something, Mr. Noor, Mr. Allen. To go forward, you'll make preparations for your witnesses to address the, our chapter 2 of our ordinance. Does that work?
Yes.
I understand, Mr. Chair. Yes.
Can we discuss when that might take place so we can have an idea of when the next hearing should be? Or do you want to do the next regularly scheduled meeting?
I guess that would be, Mr. Allen, do you require like a month to get that taken care of? Or Mr. Noor, do you require additional time? You want us to leave it open? I mean, so that you guys can get back to Ms. Eisenhower?
Well, we're prepared and have the ability to go forward tonight on all those items. So we have contract times that are clicking away and we have to move forward.
Mr. Noor?
I think our position, I mean, you'd expressed the board was hoping to go to 10. I think to be respectful of y'all's time and just the ability to understand and hear information after a certain point of the night, I think might be in everybody's best interest to put this out to another day. Whether that's in a week or in a month, we're willing to be accommodating on that. Your regularly scheduled next meeting probably makes good sense.
Ms. Eisenhower, is that doable then? Our next meeting?
Schedule meeting.
And is that going to still be contested about whether we do it virtual or are you going to require that maybe we go to a different type of facility?
If you're addressing that to me, Mr. Chair, I think the board has ruled on that objection. And so, we'll move forward however you all have decided if it's this format or otherwise, but we'll obviously work with Ms. Eisenhower and others to see if we could consent to a format going forward.
Does that give you guys a chance to give witness lists to each other? And
If the board would like us to do that, I'm happy to participate in a scheduling order that would require the applicant to produce, names of witnesses and their reports by a certain date and us to provide our responses by another so that you all could review those in advance of the next meeting. I think that obviously gives you a opportunity to review those things rather than just in the heat of the moment at a hearing.
Yeah. There's also conditions for subpoenas. Do you think that that would be required, that we issue a subpoena?
I'll have to think about that, but I can be back in touch very quickly. But that can be, I think, resolved outside of
Yeah,
the meeting.
you guys can do that amongst yourselves, but it's one of the options that we have as a quasi judicial, and didn't know if that was going to be a requirement for you to consider. Mr. Allen, same?
Yeah, and I was reminding us all what we're here for. We're here about whether it's 3 stories or 5 stories. So by the time we roll back to the hearing, we may be all back to 3 stories and moot the entire thing. So
Yeah. I don't know what to say, Mr. Allen. I mean, we tried to do the best we could. I think this is the best way to give everybody a chance to go ahead and address the issues that they're concerned about and give it a fair shake. So, I mean, if he goes back and changes the request, that's his option as well.
fair enough.
Thank you, gentlemen, for attending to the questions and bearing with us as we try to negotiate some questions that I'm sure down the road we're going to have to define our ordinances and our information a lot clearer. So,
Just to confirm, the next date will be your next regularly scheduled. I just wanted, for clarity purposes, for notice, et cetera.
our next schedule. I'm sorry? I'm sorry? Yeah, just our next meeting is what we were targeting. And if we needed to go longer, then you guys would just let Ms. Eisenhower know.
Thank you.
Sounds like the applicant's under a time crunch, so.
Yeah. That's, I'll work with them. We come back. It's fine.
On to for my purposes, your meeting is on a good night for your regular meeting, because once I get into the month, I'm in other towns all over the place.
Yeah,
So this is a night I can.
I'm sorry I
attend
didn't give
next
that much consideration, but yeah, if it works for you, then you just let us know and we'll schedule.
No, this is a perfect night for me.
Okay.
If it turns out you want to move it up, Adrian, give me a call and I can look at my schedule. I do have have the ability to have somebody to fill in for me. Some of the other slots are now finally.
So, Mr. Sneed, just for where do we go from, how do I adjourn this meeting? Do I temporarily suspend it? Do I?
You're not closing the meeting, you're just continuing this meeting to the next regular meeting of the board.
Just a continuance. Okay,
Mr. Sneed, for all the witnesses and the folks watching and us as we're writing this down, when is that next meeting?
April 5th or the 4th?
April 5th.
Oh, okay.
April 5th.
Thank you.
Okay, so we'll continue this meeting until April 5th unless things change. Thanks, everybody, for coming out tonight, for listening attentively. Coming up with a conclusion I think works for both parties, and thanks for all your input, and your questions were great. I mean, hard to negotiate, and I sure do want to make sure everybody gets their answers. Thank you for coming.
Thank you all.
Thank you. Thank you to the board.
Thanks.
Thank you. Well, I was almost going to go, my other option was, I spent 40